Check, 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 check. 1, 2.
May check ako, sir.
Check, check, check.
Sound check, sound. Sound check. Sound check.
Text ka na lang daw niya, mama.
Take your seats, please. Good morning, everyone. May I remind you that the use of all electronic devices, such as but not limited to handheld cameras, videos, mobile phones, recorders, iPad, tablets, for the purpose of taking video and recording the proceedings is prohibited. These devices must be switched off or at least turned to silent mode, as this may disturb the proceedings. Only accredited members of the media could use laptops or other similar devices for the specific purpose of taking down notes. Otherwise, said devices could only be used outside the interview room. Please rise for the honorable members of the Judicial and Bar Council. Honorable Attorney Maria Milagros Fernan Cayosa, Honorable Attorney Jose V. Mejia, Honorable Justice Aurora Santiago Lagman, Honorable Justice Regino C. Hermosissima Jr., Honorable Undersecretary Michael Frederick L. Musni, and Honorable Associate Justice Diosdado M. Peralta. The Honorable Congressman Niel C. Tupas Jr. will join us later. Please remain standing for the prayer. Almighty God, you said in your words that if two agree on earth about anything that they may ask, it shall be done for them by my Father who is in heaven. We are here right now, standing in your holy presence, seeking for your grace and guidance as the presiding officer and members of the Judicial and Bar Council perform their constitutional task to interview and select nominees for the position of Chief Justice of the Supreme Court. Strengthen the entire council, including the staff, that they may be effective and efficient in performing your will. May their every action and sacrifice give glory to your name. We humbly lift up to you the distinguished candidates who are presenting themselves before you, willing to serve your people in the judiciary with all honesty, integrity, competence, and humility. We pray, Father, that whoever will be chosen to be the Chief Justice of the Supreme Court will perform the duties and responsibilities according to your will by uniting the entire judiciary and the whole nation. We also lift up to you our friends from the media, that they may be able to cover the whole proceedings with diligence, patience, and propriety. May they all be good servants to you by giving justice to every candidate and upholding their pledge of accuracy and integrity to the viewing public. We trust you, Lord, being our supreme judge, that you will guide the President of the Republic of the Philippines and give him wisdom as he selects among the qualified nominees our next Chief Justice. Thank you, Father, for your infinite wisdom that will be upon us all today and until the day that your will for the judiciary is made known to us. We ask these prayers in your holy name. Amen.
Lupang hinirang, duyan ka ng magiting sa Session is open.
Good morning to everyone. Today, we continue the Judicial and Bar Council public interview on candidates for the position of Chief Justice of the Supreme Court. The candidates to be interviewed today are the following: Dean Amado D. Valdez of the University of the East College of Law, and Senior Associate Justice Antonio T. Carpio of the Supreme Court. This afternoon, we shall interview Associate Justice Teresita J. Leonardo de Castro of the Supreme Court and Dean Cesar Villanueva of the Ateneo de Manila Law School and Senior Founding Partner Villanueva, Gabionza, and De Santos Law Offices. May we request Dean Amado D. Valdez to remain for the interview, and may we request Senior Associate Justice Antonio T. Carpio to proceed to the holding area while the interview of Dean Amado Valdez is being conducted.
Okay. Good morning, Dean Valdez. Okay.
Good morning, Your Honors.
Any manifestation from the Dean?
May I make a very, very brief opening statement, Your Honor, Mr. Chairman?
We allowed previous nominees to give their opening statement, but we limited their statement only to 3 minutes.
We'll try to
That would be all right with you, Dean?
We'll try to beat the 3-minute time, Mr.
Okay.
Chairman.
You may proceed then.
Thank you, sir.
You will be more comfortable?
I wish to be interviewed standing until I'll request for respite, Mr. Chairman.
You may proceed then.
Mr. Chairman, I distributed my opening statement. I don't have to read this, but may I say the spirit behind this opening statement, just to summarize my entire approach to the problem. May I say offhand that we are adopting here the strategy of a triangle offense. On one end of the triangle is our vision for the judiciary and for the Supreme Court. On the other end is how to empower the human resources of the entire judiciary. And on the other end of the triangle would be maximizing and modernizing the systems. And with that approach, we summarize our proposal to it. We are asking for the creation of a constitutional court. Of course, this will be through a constitutional convention or a constitutional amendment. The establishment of integrity councils in each judicial region, merit ranking of MTC, RTC judges by honoring them with the privilege and rank of an appellate court of appeals justice without appointed as such to the Court of Appeals upon the recommendation of the Integrity Council. So this is in relation to paragraph 2 of our proposal. They are doing this in the military in a way that once an officer retires, he is automatically promoted. He receives the emoluments of an officer higher in rank. Because of the clogging of dockets, which we believe may not be solved in a short period of time, we wish to prioritize, recommend to prioritize in the disposition of cases, especially drugs cases, other heinous crimes and crimes involving tourists. The maximization and institutionalizing of mediation systems with funding, the use of arbitration systems and other alternative dispute resolutions. This is being done now, Mr. Chairman, members of the Council. We propose that a mandatory legal aid service for those who want a career in the judiciary. This will humanize those who want to join the judiciary. The professionalization and computerization of court management. perhaps it's about time that we allow internet pleadings. And adopting recording technology during trial. I saw the effectivity of this system when I attended an arbitration proceedings in Australia, where immediately after the proceedings, the parties had already copies of the transcript of records. We propose a trial by jury on a limited scale, and this will also constitute some kind of a constitutional amendment. We are proposing an ID system issued by the courts as prima facie evidence of the person's lack of criminal records. In this way, clearance will only be required if the computerized records show that that particular person has no records. So this will also part of what I call as economic development and human enhancement through the rule of law. So these are the approaches that we want to introduce to the court. But we want to say that the focus of the judiciary will be to partner with the other departments of the government in economic development, in human enhancement. I am now ready for the questioning from the council.
Okay, thank you. Dean, Attorney Cayusa, please.
Thank you, Mr. Chairman. Good morning, Dean Valdez. Well, most of the
good
questions I
morning.
prepared
coming from the Government on Corporation, we submitted to the Office of the Government Corporate Council for what we call seal of housekeeping, which we rendered legal opinions, just like the opinions which are given by the court, the decisions given by the court. And in one case which was resolved by that office was a question a question raised by a multinational milk manufacturer questioning the proposal or program of the Department of Agriculture to subsidize the raising of carabaos for purposes of dairy, to develop the dairy industry in the Philippines, saying that this is a violation of the World Trade Organization agreement. But I said that, and I researched myself and discovered that the Philippines produces only milk for our population, not even 1% of the total consumption. So I said that this is not a violation because we are not subsidizing. In fact, we are just developing the dairy industry. There was another request for opinion coming from the PCSO, where they wanted to have an internet betting. And I said, no, it cannot be done because if it's used through the internet, betting through cell phones. If you do it through cell phones, then what control do you have with children using this cell phone to bet with Lotto? And we denied. In my office, I made opinion denying the contract where PCSO could have entered allowing the cell phone as a medium by which the people will participate in the Lotto, the Lotto that was sponsored by PCSO. There are other things which I am proud that we were able to inject our own version of what should be good and what should be bad for the country. And I used the constitutional provision in that opinion saying that it is the duty of the state to protect children.
For my final question, Dean, why do you think that it is wise to consider an outsider to become the next Chief Justice?
With all due respect, I don't consider myself an outsider. A lawyer, for that matter, is never an outsider in the legal system. And I have been part of the legal system. I am a member of the Philippine Judicial Academy. I sit in some of the committees of the Supreme Court. Actually, just a levity. During the GESOP competition, I sat also at the rostrum of the justices. But I feel that I am not an outsider. If you say an outsider, that I don't belong to the judiciary. My position as Government Corporate Counsel had the rank and privileges as presiding justice of the Court of Appeals.
With that, Dean, I wish you luck. Thank you, Mr. Chairman. Thank you, Dean.
Thank you, ma'am.
Attorney Mejia, please.
Thank you, Mr. Chair. Good morning, Dean Valdez.
Nice to meet you again, Professor Mejia.
Yeah, nice to meet you.
We were together at the Ateneo during a
convocation. Yeah, now I remember po. Dean, I was going over, for starters po, I was going over your PDS and I noticed that you spent, in your postgraduate studies, for specifically your Bachelor of Laws, you spent 1 year at the MLQU and then you transferred. Why was that po?
Because I thought that I have to move on. The environment there was better. I thought that the peace and order situation was starting to deteriorate in that area. So my parents were apprehensive about my safety, so I transferred.
You also mentioned that you spent a significant period of time being with the Agrarian Reform Department.
It was only about more than a year, but during that time, I initiated what we call the Barefoot Lawyers Project.
And you were also a consultant after your being the director of the BALA, of the...
I was a consultant with the office of the Senator Alvarez because during that time we were crafting the Comprehensive Agrarian Reform Program as well as the Cooperative Development Authority Bill. And I was part of the working group of Senator Busakino in crafting the Cooperative Code. And during the time of President Cory, I sat as a member of the Cabinet Assistance System, a sub-cabinet level, where our chairman was then Secretary Facturan.
Were you already in the DARPO when the stock distribution application of Hacienda Luisita was
No, it
approved?
came later. I think it came after, during the time of Secretary Huico.
Okay. In any case po, may I know your thoughts on the decision of the Supreme Court on the Hacienda Luisita case?
Well, to me, it's not really a question whether it's distribution. To me, the more important question in this period of economic development is productivity. Will the farmers be more productive owning lands, or even without owning the lands, will they be more productive? But there's a program to be implemented. There's a law that has to be followed. Until that law is amended or abandoned, it has to be implemented. So the Supreme Court decision was a move in the right direction. I think it was also a signal saying that regardless of the personalities involved, the Supreme Court has to be independent in making its own decision.
Going to your involvement in the academe, if you were to introduce improvements in the law school curriculum, what would those improvements be?
Well, we shifted already to Juris Doctor program, and I have been trying to convince all those who are in the Bachelor of Laws to shift to the Juris Doctor, because one very important component in the Juris Doctor program is this apprenticeship. There's 250 hours of apprenticeship, and I think the best training for a lawyer is to go to the sea, to the water, in order to swim, but this takes place only after 2 years. But in addition to that, Your Honor, we also said that we have to standardize the legal instruction so that even the children of farmers and fishermen in Sulu, in Batanes, if there is a law school there, the product of those law schools will be at par with any graduate of Hong Kong or any other capitals of the world. So that we dream of the time when Emir, municipal judge, can be appointed directly to the Supreme Court. And I think when that happens, the legal system of the Philippines will be one of the best legal systems in the world.
Thank you po. For my final question, may I read one that was tweeted by the listening public? Alan Greenspan once said that the single most important contributor to economic growth is the rule of law. How do you think the judiciary affects economic growth? And what can you do in your term to help the country achieve economic growth?
Because the growth of all these economies which have improved more than us, they pinpointed some preconditions. One of the preconditions are all related to law. One is peace and order. One is political stability. Because the judiciary comes in as the arbiter of any kind of debate that may result in political instability. Then the rule of law. And also, people being disciplined. And to discipline people, especially the elite, you have to strong enforcement of the law. You don't really have any problem with the weak as far as compliance with the law. they will comply with the law because they don't have anything that will protect them. But the elite, in matters of that is crucial to the economic development of the country, they violate the laws. And the judiciary should not be a tool in the violation, in bypassing of the rule of law.
Thank you po. Good luck, Dean Valdez, and thank you,
very much, Your Honor.
Mr. Chair.
Justice Lagman, please.
Thank you very much, Mr. Chair. Dean Valdez, good morning.
Good
was
morning,
reading your-
Justice.
I was reading your personal data sheet, and I noticed that you are now presently the Dean of the UE College of Law and a member of the Board of Regents of Universidad de Manila.
That really widens my perspective. I am a member of the Board of Regents.
And then-
I used to be a member of the Board of Regents of the Polytechnic University of Laguna as well.
Aside from
From being
with the
dean,
university.
because the policy of our president is for us to grow as a person, so that the knowledge, the values, the good things that we get outside will be introduced to the university, and we are happy with that development.
aside from being a law dean, do you have any other experience in management?
As I said, I manage many lawyers. In fact, Dibala had lawyers all over the country, more or less 200, 300 lawyers. In the Government Corporate Council, we had about 60 lawyers. And I was even the statutory counsel of all the lawyers of all government-owned corporation. I managed the program, the legal aid program. That's why it was there was a success.
Of what?
Legal aid program of the National Legal Aid Program of the Integrated Bar of the Philippines,
I see.
Madam Justice.
Now, let's go to another point. You are from the academe, and I want to ask you this question.
Good morning.
Yearly, only a small percentage of examinees pass the bar examinations. As a law dean, do you think this is an indication of the low quality of legal education in our country?
No, not at all, because our mindset is about passing lawyers.
Yes.
You don't know that every student who graduates, you develop him to be a productive asset in the community.
Yes.
That's why if he graduates, he does not pass the bar,
Yes.
he can be useful in the community. He could be a leader in that community. If he does not pass the bar, then he takes the bar again, because passing the bar is really tough work. It's a bragging right, actually. But it is not a sad commentary to the legal system in the Philippines. I am the president of the Philippine Association of Law Scholars. I am exposed to all the law schools. And in fact, it is a policy I disagreed courteously to the chairman of the Legal Education Board, and when he was closing some law schools, because I believe that in these areas where law is taught, we should not close them, because this is an opportunity, especially that we need disciplined people for purposes of economic development.
So, if you will be the Chief Justice, your thinking is that there is no need to institute reforms to improve the quality of legal
No,
education.
the best can still be better, Madam Justice. We have to continue trying to reach the summit of our perfection from a philosophical standpoint.
Okay. So my next question, Dean, is what do you think are your strong as well as weak points in terms of qualifications for the position of Chief Justice?
I am well-rounded as far as my experience is concerned. I come from the academy, I write, I speak, I have long period of managerial experience. I have walked along the corridor of powers. I have met dignitaries all over the world. And I have acquired that confidence dealing with these people. And I think I can bring all these experiences to bear in my triangle approach to the judiciary.
So how about weak points? Do you think you have?
Oh, we're a
weak
human
point?
being. We always have a
Yes.
weak point, but what is important is you try to overcome the weak point. Sometimes when you have something to do, which is a priority, but you have to take care of your grandchildren because they come to you, then you have to balance it and perhaps give time. And dealing with the grandchildren will give you some kind of relief from the humdrum of the world. That's how I deal with my weaknesses, and
So
I
your
don't
weak
think
points.
I don't think weaknesses should be avoided because that reminds you of your mortality, Madam Justice.
Okay. Dean, if you will be appointed as the next Chief Justice, the Philippine Judicial Academy will be one of your responsibilities. Okay. Can you tell us your vision for the PhilJA?
I think the Philippine Judicial Academy would concentrate on human resources development as far as
Okay.
the judges concerned and the personnel of the judiciary. Philosophy. They have to be developed to reflect and contemplate. And they will be able to discover the solutions to problems. I believe that we have to empower, Madam Justice, our judges, because we cannot solve the problem from the top. We can only solve it to the soldiers below. And they will be the one to bring reforms. And I'm sure that most of those in the judiciary, the judges, they are well-meaning. They decided to be part of the judiciary because they want to render service. You have to equip them, inspire them, show leadership by example, be transparent, underscore the meaning of accountability, especially in the judiciary. I think I will have more, if I have 10 fingers with me as Chief Justice, and you have empowered the judges, there will be as many 10 fingers as there are judges in the judiciary.
Okay. Now, this is my last question from me personally. Can you tell us the advantage, if any, of having a man from the academe to lead the Supreme Court at this time?
I think those who preceded me will show the advantage of man coming from the academy. But I am not just an academician. In the morning, I am in my office. In the afternoon, I sit in the board of trustees. Later in the day, I am on public discussions. I am also the president of the Billion Trees movement. We do things for the environment. As I said, the legal aid is also one of these things. I am a member of the Rotary Club. My hands are full, but I am happy doing all these things because it's a source of fulfillment, self-fulfillment, Madam Justice.
Okay. Now, this is a question from our Twitter for Dean Valdez. Now, Dean Valdez, I will read the question. Would you entertain the idea that imposing court fees reaching millions of pesos is already a form of taxation and should be discontinued?
I think that is unconstitutional. I don't know why the Supreme Court had imposed that. I know there are problems to be addressed, the need for financial resources. But I said, this is one source that is not harmful to the people. The issuance of IDs. Because the problem, Madam Chair, when I was required to submit this clearance, I have to get a court clearance, then you have to apply. But if you have an ID, which was issued by the court already, and it is systematized, we have computerized records, then it will appear that you don't have any record. Why give additional burden to people, the man hours that is needed for economic development must be saved from the requirement of going to the court for these clearances if you have the ID. You have the ID that is issued by the court. And this, you can use it, you can generate funds, millions, 90 million people getting an ID from the court that will reduce the filing fees in courts.
So, are you saying, Dean, that if you will become the Chief Justice, you will stop the imposition of court fees?
Well, we have to sit down, we have to discuss it, but my inclination is we have to be reasonable. We have to really find the middle way. The middle way is always what we call, Aristotle called it the golden mean.
Okay.
In this world, you have to be realistic and practical, and you have to always do the middle. If this water is too cold, and this water is too hot, I will not drink it from it while I am now responding to your question. So there must be a middle mean, and we have to look for it. It's easy to look for that, as long as you have good intentions and you want to protect the people.
Okay, Dean, this is my last question from the Twitter. Based on your expertise on agrarian reform, will you kindly comment on the case of Hacienda Luisita Incorporated versus Park, specifically on the question of just compensation?
I think that is now pending. I think it has to be reasonable, but it should not be affecting very much the coffers of the country. I think that Hacienda has been already used for productive purposes. There has been income through the years coming from it. You have to go into the table and compute how much reward the owners have received from it, and perhaps we could appeal to their patriotism so that all these farmers can have these lands at a doable cost. As I said, Madam Justice, what is important is, will they be more productive will having this land? I have seen farmer leaders, they are also themselves, if you give them 1 hectare, they will employ another person. They are doing their advocacy, but they are not doing the farming. I think we should have an inventory of those who have been granted lands from this program. Between the time they got the land and today, have they reinvented themselves? Were we able to achieve the purposes of the agrarian reform program?
Okay. On that note, Mr. Chair, I have no more questions for Dean Morales. Thank you very much, Dean.
Justice Porissima, sir. Sorry, Hermosissima. Pangatlong araw na kasi. Sorry, Sarah.
Good morning, Dean.
Good morning, sir. Thank you for considering me again.
In your case, it's all right to be narcissistic because you really deserve the accolades given to you.
I did not realize I was exhibiting some kind of narcissistic tendency. I was just passionate in answering the very searching questions from the panel, Mr. Justice.
The tremendous inherent power in the hands of a Chief Justice require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence, because the administration of justice is a sacred task entrusted only to individuals with the highest degree of competence. Because a judicial post is a position of honor and is offered only to those who are best qualified. Do you consider yourself fit under this?
Well, if you want me to answer that question, I want to be narcissistic and I say I'm fit.
Go ahead, go ahead.
But in addition to the qualifications, Mr. Justice, you add to that balance. Because if you are a justice, especially if you are a Chief Justice, there must be balance. And you also have some kind of people's skill. In addition to what you said, that is in addition to the statutory constitutional requirement in the Constitution.
Now, you were talking before about the bar, Philippine bar. There is a proposal to abolish the bar and instead the examination should be made to students every year, from first year, second year, third year, fourth year. In that case, after the first year, you will know whom to be eliminated or whom do not, or those who are not qualified to become lawyers. Whereas under the present system, you know for a fact on the average about 20% only pass. So what happens to the 80%? They're jobless, they have nothing to do. Now, what do you say to that?
I have many things to say about that, Mr. Justice. First, I think what is more important is what happens to that person when he becomes a lawyer.
So,
when he becomes a lawyer after passing the bar. Okay. Now, I think that is the concern of the society because you may have a lawyer that will not protect your interests. But as far as the students are concerned, there are many reasons why a student takes up law. But as I said, there is a benefit to be derived from a person who finished law, but he is not frustrated because he did not pass the bar and he invents himself. He becomes a good asset in the society. I have seen many people who did not pass the bar, but they are presidents of their own corporations. So the time we have invested in their education has not been put to note. But going to the idea, that's a brilliant idea. As far as ensuring that that person, if he takes the bar, will pass the bar. But don't prevent him from finishing the course. Because even if he failed in the first year exams and he goes to second year, he could go back and take up the qualifying exams in the first year and second year. And in fact, I made that proposal before during our discussion because we were looking forward to that vision when there will be a barless entry to the practice of law. But we cannot do that as yet because our preoccupation with the bar examinations. But that is a very good idea, Your Honor, because you there is a perpetual weaning out of those who may not be able to make it in the bar. But my suggestion is also giving them that chance, that fair trial, to be able to achieve their dream. Even if they are now in fourth year, if they failed first, second, third, and third year, they can go back to first year, finish, take the exams again, passes it, go to second year examination. He could do it in one sitting if he is already in fourth year, and if he gets all the qualifying, passes all the qualifying exams, then you are sure that perhaps he will have a better chance of passing the bar examinations.
The examinations will be given by the Supreme Court in the first year, second year, third year, and fourth year.
In our idea is at that level, perhaps the Legal Education Board will do it, because this Supreme Court is saddled with judicial functions, extra non-judicial functions. So to spare the Supreme Court from all these problems,
maybe by the CHED or the Legal Education
we have the
Board.
Legal Education Board,
Legal Education
which is
Board.
yes, sir, Legal Education Board. But we want to, as President, I want to echo that again, because it's really a concern which time has come.
Now, if you are appointed Chief Justice to the Supreme Court, what would be your judicial philosophy?
Novus ordo seclorum. New order of the ages. And that captures the...
That's Latin. What is the English interpretation?
A new order of the ages. It's on the official seal of the United States. It's in their dollar. You will find it in the Yale School of Management. But it captures our yearning for a new order, a vision for a better Philippines. And it could start with the judiciary if this is the judicial philosophy of every member of the judiciary. Novus ordo seclorum.
Well, the integrated bar of the Philippines has a down-to-earth motto on that point, which is no master but law, no guide but conscience, no aim but justice.
High-sounding word, but it will only have meaning if it's followed in practice, Mr. Justice.
Precisely, but that's a judicial philosophy. So what is your concept of justice?
As far as the administration of justice is concerned, is a question of right and wrong. Always the high moral ground. The decisions must always pass the tests of, does it pass the test, the moral test? Is it what is good? So it's always a choice. You know, a judge is always confronted with moral choice when he makes a decision. The same way that a driver of a car who is running and there's a stoplight, but he has to catch up with disappointment in the Supreme Court because he will be interviewed by the Judicial and Bar Council. Will he beat the light or not? That's a moral choice. And you put that to the situation of a justice. Do you have to order the TRO or not? That is not just a legal question, but there is a moral question that has something to do with accountability, responsibility,
Yes,
the public desire for accountability. You know, these things are moral choices, Mr. Justice.
Yes, but you decide your cases on the basis of law.
Law is always the reflection of morality.
if your conscience does not abide by the law, will you follow the law?
The law is the nation's conscience. You are part of the nation, and you have to abide the superior. You have
If
to
the law does
follow
not-
a superior authority.
If the law does not coincide with your concept of justice, will you follow the law in your decisions?
This is now a question of policy. That's why does a judge be an activist judge, or he is a judge who follows judicial restraint? These are the choices that you make, but you cannot be a activist on one hand and then restrained on the other. That's why I propose you follow the golden mean. You have to follow what is good. There are cases which involves economic development. Will this case propel the country? In my decision, will this be critical in the economic development of this country? You know, you cannot have a pigeonhole and say you do this, you do that, you do this is law is not logic, Mr. Justice. Law is experience. It's the felt necessities of time that will be make that is the life of the law.
I'd love to discuss with you, but we have time constraints. So
I enjoy doing this, Mr. Justice.
We can do that in some other time.
So,
Maybe over coffee.
Yeah, you know. You throw me in the water if you discuss with me about these things, because I always reflect on these things, Mr. Chairman, Mr. Justice.
Congressman Tupas.
Good morning. Thank you, Mr. Chairman. Good morning, Dean.
It's an honor to be interviewed by you.
Actually, I was just listening. I was monitoring and listening. And the questions that I would like to ask were already asked. And I'm quite satisfied with your answer. So I will not ask any more questions, and I would like to wish you good luck. Thank you. Thank you.
I had some kind of shock there, because I think you mentioned that also to others, and then you came up with the strong questions. I'm sorry.
So, Secretary Mosngit, please.
Magandang umaga po, Dean Valdez.
Magandang umaga ho. Nagkita ulit tayo, Undersecretary.
You know, my wife is an avid listener of your program on radio, and I think you're a very prominent fixture in media. Would you care to forecast your role if ever you'd be chosen as a Chief Justice? Would you continue on with your advocacy in public?
No, I don't think that will be proper. I think there will be some conflict of interest involved, because my advocacy involves sometimes sharing my opinion, and that should not be the opinion of the court. You are now a walking representative of the entire judiciary if you are appointed, not even a Chief Justice, even a justice or a judge for that matter, because I know that you express your opinion through decisions. Although Chief Justice Marshall, in the Marbury case, he was the subject of many criticisms. You know what they did? He also expressed his opinion publicly, but he used a pseudonym. He made an article that was a very effective article. I think he used a name which hid his identity. And that is how he responded to the criticism of the criticism made by the public on the court.
Dean Valdez, you've been Dean of the University of the East College of Law. How would you characterize or distinguish a UE lawyer in the present times?
Oh, well, a UE lawyer is a lawyer who is steeped in ethics. That is because that's how we develop our lawyers. To us, the College of Law is a finishing school, not just a law school. It's a finishing school. Even the way you conduct yourself, you have to be acting like a lawyer. In fact, the reason why I'm comfortable with the ethical standard of our lawyers, Your Honor, is that when one of our graduates was involved in an election controversy, and he donated a room with his name there as a recognition that he was the donor of that room. And then he was involved in this controversy. The following day when I went to the office, the nameplate of that alumnus is already removed from the room. And there was no instruction from me. I did not want to do that because that is his expense. But the students, on their own, did that. That's how I think the value formation, which our college is trying to develop in our students, as well as hopefully when they are graduates. Although after that, we don't have any much control. But to control it indirectly, we came up with an award which said the Dean of the College of Law Honor Roll. That means that you conduct yourself as a lawyer with honor, and then next year you will be one of the 10 awardees of the Dean of the College of Law Honor Roll. That's how we try to reach out to our alumni.
Salamat po, Dean. If I may ask you, nanonood po ba kayo ng mga previous interviews na naka-broadcast over television? Have you been monitoring the proceedings of the Judicial and Bar Council?
On the first day, partly in the morning, but when the questions were asked and the way my thought process was affected by their answers, I said, please don't ask me to watch it anymore because I may not be original anymore when I answer the questions. I don't want to prepare. I want to be original because I want that my answer will come from the heart. That's why I am a little passionate because it comes from the heart, Your Honor.
I wanted to ask you, this really is just to elicit your response. What do you think about the proceedings? How is it being conducted? Do you think it's adequate? Do you think it's orderly in the selection process for the highest position of Chief Justice?
I think I have to doff my hat to the presiding officer and the way the questions were propounded now. I am very happy, as if you are my friends. But in the process, you make me respect you more. This is the feeling that I got during the short time that I am here with member Cayosa. I met her during the National Convention last time, remember, at Subic.
Dean Valdez, I'm sorry to interrupt you, but I really wanted to find out if a national televised proceeding for the selection of a Chief Justice is appropriate in your opinion.
We should not overdo it. Perhaps whoever will be appointed as Chief Justice will be a Chief Justice for a while, and this spectacle may not be reiterated anymore. Suffice it to say that the public has a window to see how you do it. I think next time around, I don't mind these things, but next time around perhaps it might reach to the point that the public there will trivialize what we are doing. But to the point that we are doing now, I think I am very satisfied. But to make it as a practice, I have some reservations about this, Mr. Secretary.
As a last follow-up to that, do you think it's an adequate measure or a way to gauge the competence, integrity, probity, and independence of each candidate for the position of Chief Justice, the proceedings that is being conducted right now?
I don't think they should be debating on a rhetorical contest. I think it should be more. I think this should just be an opportunity for you to read in between, so that you can be able to have an informed decision. But there must be a totality of your evaluation. I believe that you will have some information about us. And in the last analysis, it's really your conscience deciding on the choice that you will make, Mr. Undersecretary. Mr. Vice Chairman. I think you're the Vice Chairman.
No, I'm not. I'm pro hoc vice here. I'm saling pusa. Just moving on, sir. I was very intently listening to your views on the court fees. Just a very quick point. I am certain that you know the difference between an administrative charge or a fee as against the tax. The fee being imposed by the court is for its administrative expense, just to run the regular business of court administration. And the Chief Justice, all we know, is the CEO, really the big boss in court administration. How do you then weigh this in your view that the fees are the fee system is needs to be revisited?
There are many values involved. I think the most important value that is being affected by the high fees, access to justice. And between access to justice and the requirement for in the administration, the management of the court, I think we have to give more premium to that value of access to justice, because that is the essence of our democratic system. Fair opportunity, the opportunity to seek redress for their grievances.
I have two more questions, if I may. I was listening to you earlier when you were talking about your grandchildren. I know a sense of fondness that you have of them. And my take is that this is because you see in them the future. And I'm sure you're very interested in legacy. In that sense, as a lawyer and whether or not chosen as the Chief Justice, what do you think, what is your aspiration to be, your legacy in this country?
The sense of posterity, you mean, I think, and I hope to make the difference in the administration of justice. That's why the motto, "A New Order of the Ages," is very important to me, because the different prescriptions that I submitted may be developing the new order of the ages. Perhaps it may help in the liberation of the people from poverty. We just hope that if we think outside the box, come up with some ideas, and perhaps for the first 20 years, our focus would be economic development. And the Judicial Department will be helping in that idea of economic development through the rule of law. Because my motto, the vision in the triangle approach that I said is economic development and human enhancement through the rule of law. Then I could have made the difference.
My last question is, the Constitution right now provides that bars foreigners from practicing law in the Philippines unless provided for by law. Do you think that it is now time to allow foreigners to practice law in this country by legislation?
Well, as a dean of a law school, my inclination is not to allow foreigners to practice law. But as we expand our horizon and as we expand the economic umbrella that we have, perhaps on a reciprocity basis, we can do that. But you should be reciprocal with another country on equal basis. If you try to be reciprocal with a big country with all the resources that we have, in reality, that is not reciprocity. It will just be on paper. So I want a reciprocity that is not just based on paper, but on the reality on the ground.
On that note, Mr. Chairman, I'm sure you have plenty questions to ask. I give it to the chair. Maraming salamat po, Dean, and good luck po.
Thank you.
Alamatan ni Dean Valdez, ako nang susunod magtanong kaya binigyan ako ng magandang compliment. Thank you.
Salamat po.
Ito ang tanong ko, Dean Valdez, is humility a quality?
It is
Chief
equality.
Justice?
It is equality. Is important. Humility is important. But modesty could be more appropriate because sometimes if you overdo the humility, it may show weakness.
But humility is part of judicial temperament. And I think judicial temperament is one of the important qualities, aside from the qualifications provided for under the Constitution. Do you agree with me?
That's true, but you must be able to assert yourself also. If you are a leader of the court, you must be able to assert yourself without being disrespectful to your colleagues.
Yeah. So we agree on that.
Yes, Your Honor.
Humility is part of judicial temperament, and judicial temperament is a quality, one of the important qualities of a jurist, not only a Chief Justice. Okay. Now, did I hear you right that you want the collection of fees declared as unconstitutional?
I was just musing about it because it denied access to the court. Perhaps it has to be revisited, and perhaps the Supreme Court has to do it upon itself to review this and make it more consistent with the aspiration of our people to justice.
Hindi mo po ba alam din, Amading, ano po yung fees na yan sa Rule 141, yun na nagpupundo ng Judiciary Development Fund. Ang Judiciary Development Fund, provided for po ng batas yan So, kung walang fees yan, saan anong pagpa-fund namin sa Judiciary Development Fund?
I think that was the trust of...
Pangalawa, part of the fees that we collect, pupunta rin sa 9227 yung Republic Act 9227 Yun ang tinatawag na SADS. Ngayon, yung Judiciary Development Fund, for your information, part of that goes to the employees. Yung lowest ranking na empleyado ng Korte Suprema, mas malaki ang tatanggapin kaysa sa justice ng Korte Suprema. Reverse. Pag mababang sweldo mo, mas malaki. Kaya kami sa Supreme Court, mababa lang yung allowance namin na nanggagaling sa JDF Yung SADS naman, ito po ginawa ng ng Congress at Senado Unanimous yan. Yung sa 9227 para mapagbigyan ng mga huwes at saka mga justices ng additional income noong 2007 nag-create sila ng special allowance for judges and justices. Iyon po, hindi po yung nagpupundo doon, hindi po nanggagaling sa budget. Nanggagaling po sa fees. At yan po, kung may sobra doon sa SADS ng mga judges at saka justices, yung hindi directly benefited, yung indirectly benefited, ibinibigay po namin sa mga empleyado yan Yun po binibigay namin sa empleyado. Kami ay natutuwa dahil ng balita na ginawa nung SADS noong 2007, naku po, ang budget namin less than 1%. Kaya nagpapasalamat sa sa Congress. We are hoping na hindi na nila babawasan Gusto ka namin sana nandito katabi ko si Congressman Tupas. Nalalaman na niya kung anong trabaho sa Korte Suprema. Baka dudublehin na Ganon po yun Okay. Now, you were also talking about...
Now, can I address that issue first, Mr. Chairman? Because I did not advocate the abolition. I just said that perhaps we have to review it and perhaps to make it reasonable. At saka sinasabi ko po, yung ID na pinupropose ko, it might generate funds.
Para hindi masyadong hahaba, no? Linilipit ko lang yung questions ko muna doon. We will take another topic and then you have to just listen from me. Then you are send the question as they are questions as they are propounded. Para, kasi meron pang isa. Yung susunod, baka mas mahaba. So, pagbigyan naman natin yung isa, po. Tsaka, kinakailan din namin ng break Okay. What I would like also to ask from you is, medyo, nagulat ako nung sinabi mo na the issuance of a TRO should be based on moral ground You want to amend Rule 65? Alam mo itong Rule 65 sa tingin ko hindi pa tayo abogado Nandiyan na sa Rule 65 Ngayon ko lang nalaman sa inyo ay dapat nagdagan ng moral ground ang issuance ng TRO Ngayon ko lang nalaman yan
Hindi ko naman sinabing
moral choice
kasama yung moral ground, Mr. Chairman.
Mali ang pagkarinig ko kasi mali ang pagkarinig ko. Okay, go ahead.
Ang sinabi ko, a judge or justice has to make a moral choice. Now, the way I understand it, pag ibinigay mo yung TRO, yun na yun Hindi naman actually TRO yun. Alis na yun Hindi naman talaga. I'll just because I made that in reference to that, Mr. Chair. Let me finish it because I don't want the public to misconstrue me, please. Because I don't want that the language of the TRO be corrupted. If you say TRO lang yan. Pero kung nakaalis na yung tao, hindi na TRO yan.
Referring to a specific case,
I was referring to that specific case, Mr. Chairman.
So,
I'll be honest with you.
So, if that is the case, then magiging discretion na ngayon ng husgado, ito, moral choice ko ito Kaya dapat hindi ko i-issue ganun nangyayari yan. Kasi I'm not referring to specific case Here comes an applicant for a TRO. Gigibay na yung bahay niyan. Sasabihin niya, wala na kaming titirahan. Yung mga naghihirap ng mga kababayan natin, tinatanggal na ng NHA, lahat-lahat. Sabihin na natin, hindi sa kanila yung lupa. Pupunta sila sa husgado ngayon, mag-a-apply ng TRO. Just tanungin ng judge, ano at ang moral choice ko? Ganun ba yun?
That's why you have to use reason. The moral ingredient must be coupled with reason. And you have to weigh it. Kaya sabi ko kanina, you have to balance things. Hindi ko pwede yung sunugin, wag sunugin. That is not what I was saying. You have to look into the totality of what I said, Mr. Chairman.
So there's no need to amend Rule 65?
No, there's no need to amend that.
Agreeable tayo dyan.
Wala ho tayong pinag-aawayan dyan. But you are just injecting something which I did not say.
But I will ask you again, moral choice is not an element.
No, I'm sure.
So tama na. Basta clear tayo dyan.
Hindi ho.
Kasi mabigat yung moral choice Kawawa naman ng mga judges Kung ang choice na, kasi
what I said is that a judge or a justice may always exercise such kind of moral choice. But there must be reason to it. Hindi pwede yung moral choice, nararamdaman mo, mahal ko ito, nararamdaman ko itong ganito.
Hindi ganun ang huwes, hindi ko nararamdaman I will interrupt you on that.
Hindi ko naman sinasabing ganun. Sinasabi ko, you should have some reason.
I'm the chair, you have to listen. Meron kaming rules. When the chair is talking, do not disturb him. Please lang.
Yeah, but please do
I allow you to answer already.
But please do not put something in my statement.
No, I'm just following what your answers are Yun lang Kasi mabigat yung sinasabi mo tungkol sa TRO Biro, may harapan ng judges dyan. So anyway, I'll go to another topic. Yung creation ng Constitutional Court, you agree on that? The Supreme Court cannot do anything. That's legislation.
Yes. It's perhaps through a constitutional amendment.
Yung establishment of integrity councils, hindi ba?
Is judicial region.
Are you aware that we have already a resolution approved by the NBank?
Well, that's good.
It's already being printed.
Is it implemented already, Mr. Chairman?
Yes, it's already being printed.
That's good.
It's already for distribution, for your information. Yung merit ranking of MTC, RTC judges, mabigat itong hinihingi mo eh. Bibigyan mo ng rank ng Justice ng Court of Appeals. Alam mo kung bibigyan mo ng rank ang MTC, RTC judges, they will ask for benefits equivalent to the benefits being received by the Court of Appeals.
That's why it's an idea that you have to be fleshing out. These are all proposals which will need to be fine-tuned.
That's why.
So when you say this and you read it, don't judge it because you have to make a counter-proposal. What's your counter-proposal to this?
Well, that's why I'm asking you, because if you become the Chief Justice, at least malalaman kung ano itong proposal mo, ano? Okay? Special priority to drug cases, other heinous crimes,
Yeah,
and
this is
crime.
being done now, actually.
What? We have been done. Okay. Alam mo ba kung you put this special priority to drug cases at saka other heinous crimes, probably because you are thinking of a delay. Hindi ho ba?
Ganito ho yun. Kung bakit ganyan. Alam nyo yung mga witnesses dito, drugs cases, these are undercover agents. So, pag binistahan na yan, makikilala na yan sa community. But if it will take 1 year or 2 years bago, that guy will be ineffective. Kaya ang ginagawa ko dapat, the ideal situation tapusin mo na ang testimony niya, and then iyasay mo na sa malayong lugar para no one knows about him and he will be effective there. Kukunti lang ho ang police natin that are specialists on these things. This is the reason why there should be special priority to drugs cases.
I thought you want this also because you want to improve the docket of the courts.
This proposal is not a proposal in a vacuum. There is experiential dimension to this.
You want a better conviction rate?
It's not really conviction, but tapusin mo. Yung hearing, para you can be able to you dispose of the case and you are able to utilize the resources of the government on other things. Kaya sabi ko nga, undercover agent, lumabas na yan. Magagamit mo ba dito sa Metro Manila? Papatayin na ho yan.
Okay. Ako naman, wala kaming, ang husgado, walang control sa witnesses may control ng witnesses sa prosecution yan at saka mga pulis Kaya tinatanong ko sa iyo, kung ito special priority drug cases, within our means, ano mang kinakailangan natin gawin dito? So I was asking you, i-expedite ba natin? Tinatanong mo, mga witnesses, wala pa kaming control doon Sa ano yan mga pulis yan, saka mga piskal yan
Ano, Mr. Chairman, behind this proposal would be the work of the judge. How will you be able to supervise your court? How will you able to make the witnesses available? It's in the management ability of the presiding judge to marshal these resources. Siya ho nagdidikta niyan He has control.
Alam mo, pag yan ang ginawa mo, pagsususpetsaan ka. Kung ang judge maghahanap ng witnesses, siya ang bahala sa witnesses. Pagsususpetsyan ka ng kabila.
Tingnan nyo.
Ang witnesses, problema ng prosecution yan
But how do you do it na hindi ka pagsususpetsahan?
The prosecution will ask for a warrant of arrest. That's all the judge can do. Nandyan sa rules natin yan
Well, you have to be creative in order that you address the principle of openness, yung principle of accountability, yung principle of efficiency. Ando doon ho sa management ng court yan
Pag yan ang ginawa mo, walang mag-apply na judge. So anyway, I'll go to another one.
I'm sure there will be many.
Crimes involved. Alam mo, nanggaling ako sa judge You were also appearing before me. Many times you observed me
Yes.
I know, he's a good friend of mine.
Yes,
Inobserve mo ako
You were one
Sa
of the
tingin ko, you
best,
can confirm that probably I was one of the fastest judges in the city.
No, this is just anyway discussion.
Discussion lang yan
But our friendship is...
but you can confirm. But you can confirm that you were you're
one of the best trial judges.
I know you observed me when I heard that when I was the one who heard the case of that famous policeman who shot a young boy. Yeah, that fellow. I know you
Yeah.
monitored me. All the lawyers of IBP monitored me, no. Kaya magkaibigan tayo eh.
Kayo ni Justice Bersamin.
Oo, kapatid Justice Bersamin, tama yan, no? Hindi kasi, clarify ko lang ito, because these are the proposals of Dean Amading. Yung maximizing and institutionalizing funding of mediation system, arbitration,
ginagawa na ho yan.
Ginagawa na yan, okay, ginagawa na yan. Ito ang problema ko eh. Amendment of the rules on pleas, allowing no contest pleas in certain cases and imposing community service as penalties, particularly to youthful offenders eh. Ito, di ko masyadong maintindihan.
Kailangan
din
siguro ng legislation dyan, Mr. Chairman.
No, but di maganda itong suggestion yun eh. Allowing no contest pleas in certain cases eh. Hindi ko po masyadong maintindihan because ang experience namin, in our experience, that's why one of the reasons why we have a heavy load of drug cases, ito sa plea bargaining eh. That's why I was asking you anong problema sa drug case. I thought you want the law to be amended eh. Kasi, alam mo, Din Amading, nakikinig si, nakikinig si Congressman Tupas, no? One day, probably, ito, proposal ko lang naman, yung mga members ng court, members ng judiciary, imbitahan naman kami minsan sa, public hearing, kung pwede lang, para we can share our observations. Kasi itong drug cases, ang delay sometimes, nasa batas, Hindi sa pulis, hindi sa husgado nasa batas Bakit kamo? Walang plea bargaining. In-incorporate natin sa rules of court ang plea bargaining para mabilis. Mabilis ang takbo ng kaso. Inalis po yan sa plea bargaining sa drug cases. Pangalawa, dahil pinagsususpetsaan ng fiscal, police, judge, ang ginawa nila, in-incorporate nila yung Section 21. I do not know kung alam niyo. Alam mo marahil yun, yung Section 21, 1965. RA 9165. Meron yung mga chain of custody doon, kamera-kamera, ang daming requirements So, nagko-complain yung mga police. They cannot comply, acquit. Hindi ho ba? Ganon din tayo sa Korte Suprema Pangatlo, yung dating law, sa Republic Act 6425, ang penalty nun, based on quantity Based on quantity. Sa madaling salita, example lang yung shabu nun pag 200 grams, I think, reclusion perpetua to death. Pag mababa sa 200 grams, graduated ang penalty, depende sa quantity.
Dinadagdagan pa nila.
Ang gagawin kasi, ginagawa kasi ng mga pulis noon, daw, yung nakakarit. Binabawasan. Tapos yung kinuha, i-recycle. Hindi ho ba?
Yeah.
Pinalitan yan Pinalitan ng batas Pag sale yan, regardless of the quantity, life imprisonment na yan. Hindi ba? Tapos tanggalin mo pa yung plea bargaining, lahat ng kaso nandun. Hindi ho ba? Kaya that's why I wanted to ask you kung anong problema sa drugs. I thought that ito isasagot mo Kaya lang ini-interrupt mo ako, Din Amading Kasi I wanted to say that, kasi nandito si Congressman Tupas. Even if you go to the courts, namamasyal ka sa korte tanungin mo sa husgado lahat kung anong cause ng delay at saka anong mga cases na pending na matagal dyan. Drug cases Hindi ba?
Pasensya ka na, Mr. Justice.
Nag-uusap
lang tayo as usual
Akala ko, para sa iniisip natin, iba pala So anyway, insofar as crimes involving tourists, merong batas dyan nang sinasabi, whether a tourist is a witness or an accused, mateterminate ang trial within 72 hours yan. Hindi ako nagyayabang, kasi meron akong quality of humility Kaya lang, hindi ito. Nasa yan? Kayong mga students, alam niyo yan, yung People versus Marty. Basahin niyo yan.
Illegal search.
Illegal search. 72 hours, tinapos ng husgado Tinapos ni Justice Caldejo I was only an assisting fiscal. Meron ibang fiscal doon. 72 hours because we follow the law Mayroong batas dyan Hindi ho ba?
Kaya
meron.
dapat yun ang good example ng disposition of cases.
Yan. Yung mandatory legal aid service, I think it's incorporated doon sa MCLE program
O nga, pero
yun.
ang proposal ko during our IBP forum is, kung maaari, yung mandatoriness, yung gustong magkaroon ng career sa judiciary, sa prosecution, sapagkat ang naisip ko, this is based on personal experience in my stint as legal aid director noon, and even before that as legal aid committee director sa isang chapter. Nakita ko yung humanizing effect sa akin nung nakikita ko yung mga farmers na inaalis do sa kanilang sinasaka.
Tama ka.
And since then, I became an advocate on agrarian.
I think we agree on that. Dapat may legal aid service, no? Okay. Yung professionalization at computerization of court management, meron ng tumatakbo dyan. Effective nga sa Court of Appeals. Meron konting problema sa RTC, sa mga trial courts. Kasi iba ang procedure in the Court of Appeals and the Supreme Court because walang trial work sa Court of Appeals. So it's easy to monitor. You file the case, follow some pleadings, tapos na
Kaya
sa trial court, file ka ng case, arraignment, pre-trial, trial, and so on. Marami hindi ba? So, but anyway, it is a...
I-clarify ko lang kaya kinisingit ko ito, maski meron na tayo, because of the ID system proposal. Because the ID system will not be effective without computerization.
Okay. Yung allowing internet pleadings, ginagawa na ho namin yan sa Korte Suprema. We receive pleadings through the internet. Ang problema lang sa initiatory pleading, mahirap yun kasi binabase yung fees sa initial pleading kung i-allow mag-internet pleading to, paano masisingil yung fees? Kawawa naman mga empleyado namin, wala silang JDF, mga judges, walang SADS So anyway, probably...
Pwede na ho magbayad ngayon sa internet
Yeah. Tingnan natin din. Recording technology, we are doing that Kailan problema? Budgetary constraints Pag ginawa mo lahat ng husgado yan, entero Pilipinas, naku po. Nandito sa Congressman Topas, susuportan kami. Walang problema yan
Ang suggestion ko, Mr. Chairman, pilot natin sa Iloilo.
Wow, hindi, meron na kaming pilot. At saka din, sasabi ko sa iyo, sa reform program ng Supreme Court, probably, pagkakataon na rin ito, yung amendment sa rules, kapag tinitingnan nyo, marami na kaming ginawa sa rules para ma-expedite. Marami na. And we are trying to adapt rules from other rules para i-hybrid namin Let's say yung rule on summary procedure. Hinhybrid namin sa rules for procedure for environmental law. Yung intellectual property rules, hinhybrid namin with rule on summary procedure. Inadapt na namin yung judicial affidavits. And then we adapted some principles doon sa Amerika. Tulong sa mga tao sa gobyerno. I'll give you an example. I do not have read yung mga practitioners sa Amerika, alam nila Si Attorney Matters, I think meron tayo isang lawyer from, I think, practicing in America. Yeah. Meron kaming, alam mo sa environmental law. Kaya visionary ang Supreme Court Meron kaming slap suit ngayon. Slap suit. Under the rules of, alam mo yung slap suit, ang ibig sabihin nun strategic lawsuit against public participation. Pag ang forestry officer, or mga nag-i-implement ng environmental law, bebeltaan ng malaking kumpanya, file cases, file sa ombudsman, file ng damages, yung officer can put up that defense that is a slap suit. And what the beauty of this is, you can just establish substantial evidence dismiss na yung kaso sa kanya Sa tingin ko pwede natin i-apply sa ibang government officials yan Hindi ba? Para matakot ng magpapel ng mga cases to vex or to harass yung mga government officials natin Isa pa. Ito rin I do not know, you know also, para malaman nyo kung anong ginagawa ng Korte Suprema, alam mo yung photographs din, Amading, hindi ba? Yung photographs ba, can it be admitted as independent evidence to prove what is depicted in the picture?
Well, I think depends on the purpose. But if to prove what is depicted there, baka mayroong kailangan...
No, independent. In other
Yeah.
words, what is depicted there can be an independent evidence for the conviction, ano? Of an accused, eh. Nalaw namin dyan sa rule for procedure, eh. Kasi ang problema dyan, yung mga catalogs, paano nila dadalhin sa husgado? Yung mga isda, hinuli ng illegal fishing. Pagdating ng trial, wala na yung isda. Kinain na. Ay, hindi. Hindi na preserve, eh. Ang sinabi namin, photograph na lang. And then somebody will testify on the authenticity. The one who took the picture, present. Pwede nang i-admit yun. Hindi mo na kinakailan dalhin ng drugs. Sa tingin ko, pwede natin gawin sa drugs law yan, eh. Ang problema, it needs a legislative act, eh. Sa drugs court, kaya nandito nandito. So in other words, ang husgado naman natin marahil ay ginagawa lahat ng paraan to help our people din. Okay? Nakaintindihan tayo dyan, ano? Tama ba?
But I always believe your stint has been a model for other judges, Mr. Chairman.
Oh, thank you very much. Ni-remind ka lang ata, no, medyo nagdebate tayo ng konti. On that note, Dean, no, I'm true. Ha?
Maraming salamat po if I offended some sensibilities. Pasensya na ako kayo
Hindi.
it's just part of...
No, that's part. Ganon din kami sa Korte Suprema, nagdedebate din kami ganyan-ganyan. After the session, we take our lunch together as if nothing happened. Para sa bayan, eh. Wala tayong para sa bayan, walang personalan. Otherwise, walang mangyayari sa bayan. Salamat po.
I am honored to appear before the council. Thank you very much.
Thank you din.
Okay lang?
By all means.
Okay. Okay, thank you.
Your Honors, the Honorable Senior Associate Justice of the Supreme Court, Antonio T. Carpio, is ready to be interviewed.
I'm now in a quandary. Who will I address the nominee? Because when he presides the NBAC, we call him chief. When he presides in the division, we call him also chief. But because I'm now the presiding officer to determine if he possesses the qualifications, ano atang tamang address ko sa kanya? Ha? So anyway, can I just address you, Justice Tony, in the meantime, Chief? Okay. Now, do you have any manifestation? Okay, so you are now ready with the questions? Okay. So, as requested by Congressman Tupas, and there being no objection on the part of the other members of the JBC, because he has to rush to Congress to fight for our budget, for our budget, and probably to ask for an increase. Kasi nadalaman na niya anong trabaho natin eh. Okay. Congressman Tupas, please.
Thank you very much, Mr. Chairman, Justice Peralta. Thank you very much, members of the Council. Magandang umaga po, Chief.
Good morning, Your Honor.
Ang unang katanungan ko lang, Chief, no, yung siguro of all the incumbent members of the judiciary or the Supreme Court, siguro ikaw yung pinakatamang tao na sumagot nito, yung regarding po sa seniority. Kasi tinatanong ko kanina, yung dati pag nagkabakante naman yung position ng Chief Justice, halos mga justices lang talaga yung senior yung nag-apply, yung seriously consider. But now, na-open yung process. At marami pa nag-apply na outsiders. And when we impeached the former Chief Justice of the Supreme Court, of course we impeached the person. That was our thinking. But more than that, we're thinking also of reforming the judiciary and the Supreme Court in particular. Yun yung nasa isip po namin nung ginagawa namin po yun sa Kongreso. At ngayon may naririnig ako na sabi nila, may sektor po na sabi, mas maganda siguro ang outsider. Kasi paano mo ma-reforma yung sistema na mas matagal pa sa atin, di ba? Itong sistema dito, ang dito na tayo, parang kultura na ito. Yung mga problema natin. Paano ma-reforma sa sa mga taong andun na sa matagal na panahon rin? So, you can answer this, Chief, siguro, yung mga small questions na to, you can answer it, siguro isang sagot lang very briefly, na maapektuhan ba yung moral? Assuming hindi insider yung mapili. Just assuming yung mapili yung outsider, maapektuhan ba talaga yung moral sa loob, honestly? Anong effect nito sa Supreme Court, sa judiciary? At ano ba yung ano ba tingin mo dito sa seniority na issue pagdating sa Supreme Court? Assuming na pinili yung senior o isa sa anim, makaka-institute ba talaga ng needed reforms ito? Considering na ang problema matagal na ito At okay lang ba? Kaya ba ito ng insider na isolve yung problem? Siguro very briefly lang, Chief, those questions.
Thank you. First of all, we have to follow the Constitution, and under the Constitution, the President has the prerogative to appoint anyone in the list submitted by the JBC. So we do not question the prerogative of the President. Now, notwithstanding that, there has been a tradition that the Chief Justice will be chosen from the senior justices of the Supreme Court. At least, I think there was...
Tradition po. That's a tradition.
Yes, that is a tradition. There was only one instance when the Chief Justice was appointed from the outside, and that was during the Japanese occupation. So, that has been a tradition. It's also a tradition in the appellate courts, like in the Court of Appeals. The presiding justice is chosen from the senior justices, also in the Sandigan Bayan, and even in the Court of Tax Appeals. So that tradition has encouraged the incumbents in the appellate courts, including the Supreme Court, to look forward to the day that they will be senior and will have a chance to become Chief Justice. Now, will it demoralize them? I will not deny that it will be bad for their morale. But I will also say that the President has that prerogative. The Constitution gives him that right. It is like, for example, in the Armed Forces of the Philippines, the President is authorized to appoint as Chief of Staff of the Armed Forces anybody from the rank of Colonel up. But can you just imagine if a Colonel is appointed Chief of Staff, although the President has that prerogative, tradition, wisdom, and everything else could dictate that he must appoint somebody senior among the general staff. So there are pros and cons here. Now, you're talking about, is it necessary to appoint an outsider to reform the judiciary? Well, in my view, I don't think it is necessary because you have impeached the Chief Justice and his person. You have not impeached the rest of the court, And we in the court we don't decide cases unanimously all of the time. In contentious constitutional cases, there are a number of justices who register strong dissents. So I don't think you can say that because the Chief Justice has been impeached, the entire court is also impeached. There is no guilt by association.
Wala pong sinasabing gano'n.
Yeah,
No? Hindi po sinasabi yun. Naniniwala po ba kayo sa tradisyon na yun na seniority na sinasabi niyo?
Well, the tradition
When it comes to the Chief Justice po na position.
Yeah. We have a tradition in the Philippines, and that is, it has worked well for us. In the United States, they don't have this tradition. The Chief Justice can be appointed from the outside anytime. So it's a question of, there, if you appoint an outsider from a Chief Justice from the outside, there will be no demoralization because they expect that. Here, people expect that you appoint from the inside. And I think that is the situation here. But again, I want to emphasize that it is the prerogative of the President to appoint anyone in the list submitted by the JBC. And I'm the first to respect the Constitution. If the President appoints an outsider, I fully respect that.
And let's say, assuming po na mangyari yun, you can work harmoniously.
Of course.
Okay. Yung kapansin-pansin po, no, nung before ng trial, ng impeachment, January 16 kasi yun eh. Yung period from December 12, 2011, tsaka January 16, di ba? Maraming batuhan doon eh, na naging personal. And lumitaw yung pangalan po ninyo doon, di ba? Na inatake rin kayong personal. Pero kapansin-pansin po sa akin noon that you exercise also self-restraint. We were expecting you to hit back rin. Well, we were expecting, yun naman ang natural, hit back. Pero tumahimik po kayo eh. Diba? So, I just want to know what were you thinking at the time? No? Parang gusto ko lang po malaman yung iniisip nyo na, yan talaga, karakter nyo ba talaga ho yun na Justice Carpio? Or parang sabi mo, sige, dyan naman yung Kongreso eh. Dyan naman yung Committee on Justice eh. So, gusto ko lang malaman po because it's important to me na malaman yung karakter nyo rin po for this nomination.
Well, I maintain my silence for several reasons. First, there were pending cases in the Supreme Court regarding the impeachment. And if I have to say something, I might be asked to inhibit in these cases. I didn't want to inhibit myself. Secondly, I take a long-term view of these things. At the end of the day, all these accusations will be exposed as false because I know they're not true. Like, I was accused of being one of those who schemed to impeach the former Chief Justice, that I was scheming with President Aquino and with Secretary Marojas. But I'd never talked to these people. In fact, what they're saying is, I'm not close to the President, that's why I won't be appointed.
Sino po nagsabi?
People are saying that. But
So hindi po totoo nag-scheme kayo? Hindi
of
totoo.
course, you would know that because I never talked to you. I mean, how can I convince about 168 congressmen to sign the impeachment?
Hindi po. That's not the issue, yung convince. Kasi wala pong makakonvince. Kahit sa akin po, walang makakonvince. Isa lang ako. So yun po yung mga reasons. Bakit tumahimik? Yung gusto ko lang malaman, bakit kayo tumahimik? Yung self-restraint.
Yeah, because there were pending cases. I didn't want to inhibit myself from these pending cases.
Nung impeachment po, yung sinasabi namin that it was necessary for us to restore the independence, credibility, honor, and integrity of the judiciary and the Supreme Court in particular. That was what we believed in. May kabilang panig naman po, nagsasabi na that was an affront or attack on the independence of the judiciary. So I just want to know your philosophy dun sa process. Was it really an attack on the independence of the judiciary? Or was it, sa inyo, it was a necessary thing para sa institutions na nagbanggaan po eh. Banggaan yung tatlong malalaking branches of government. Parang it was a battle of the giants. necessary po ba yon para kailangan restore? Or it was totoo na it was an affront on the independence of the judiciary?
Well, I did not take that as an affront on the judiciary, because I always look at the Constitution. The power to impeach lies with Congress, and that is part of the checking mechanism. That's part of our democracy. That's in the Constitution. If Congress deems it wise to exercise that power, then it will proceed, and we cannot complain because the Constitution authorizes that. That's the way I look at it.
Nung marami po may sektor rin, no? May sektor rin, let's say, sa legal profession na sinasabi nila, okay yan si Justice Carpio, eh. Diba? It's a safe choice. The most senior, Associate Justice, 10 years, para mag-11 years na sa Supreme Court, malinis. Pero yung law firm connection kasi, yun pa rin eh. Parang dun po yung tanong ng iba eh. Malakas ito dati, di ba? Tapos babalik na naman itong lalakas. At dihado naman yung mga ibang law firms. Yung mere inhibition, for example. Alam naman natin yung inhibition, hindi naman ibig sabihin na wala na nangyayari, di ba? Pwedeng sa likod gumagalaw eh. So, what's the assurance po? Na assuming po na kayo yung mahirang na like ngayon, acting Chief Justice, talagang permanent na Chief Justice po kayo. Ano po yung assurance po, let's say, not just the legal profession, but yung mamamayang Pilipino na yung isang issue na to na binabato sa inyo talaga, di ba? Yung law firm connection, CVC. Anong assurance po natin na hindi po makakahadlang yon sa pagiging isa sa pinakamabuting Chief Justice kung sakasakali?
Well, I have inhibited in all cases of my former law office. The mandatory rules of the Supreme Court say that you have to inhibit for the first 10 years. I have inhibited in the first 10 years, and I still continue to inhibit up to now. And I will continue to inhibit in all their cases until I retire. Now, you mentioned about back-channeling, talking to other justices.
Yes.
Well, I have never lobbied with any of the justices. You can ask any of them if I lobbied with them for anybody. I have not. And I don't even visit them in their chambers. I have never visited the chambers of any of the justices. I have not visited the chamber of Justice Peralta. So,
Chief, excuse lang, yung question yung assuming na ikaw na yung Chief Justice, di ba? At mag-inhibit nga kayo. Okay yun, may inhibition. Pero do you have all, parang may wrong ba kayong parang, do you think it's your parang moral duty rin na sabihin, let's say na, wag kayo, kung hindi kayo ang magbaback channel, magbaback channel dyan yung law firm. Diba? Yun yung fear ng mga ibang tao eh.
Well, I don't want to say any comment on those cases because that could be misconstrued. So I just refuse to discuss these cases with them because anything I say could be misconstrued. And you can ask any of the justices if I ever approach them on any case, not only for my former law firm, but for anyone. And I've maintained the day I joined the court. Now, if they want to join me in my ponencia, I welcome them. But I do not even go to them, even in political cases, I don't even go to them in their chambers to try to convince them on constitutional cases. If they want to join me, they can join me. That has been my policy ever since.
Okay po. We go to the next question. Ito po yung naging parang mag-11 years na po kayo dito as Associate Justice. Magdadalawang buwan na po kayong Acting Chief Justice. At yung premise po kasi namin po at least kami sa direct representatives of the people, may problema talaga yung judikatura. Sa amin, may problema talaga. Not just judiciary, yung Supreme Court mismo. Sa tagal ng panahon nandito po kayo, especially ngayon, kasi nakikita nyo po, kayo na eh. Marami tayong sinasabi yung transparency of JDF, SAJ, Special Allowances for Judges, yung mga sobra-sobrang masikip na yung mga jail natin. May mga sinasabi rin tayong mga clogged dockets, kulang buildings, salaries. Para po sa inyo yung transparency yung degree of criticism na matitake ng korte, not just the Supreme Court, but the judges as well. Pero I just want to ask you po, kung merong single most important issue problem po ng judikatura na kailangan immediate solution, ano po yun? Based sa inyong ano ngayon, Acting Chief Justice.
Well, the number one problem of the judiciary, I think, is the clock dockets. Okay? And I have proposed how to solve these clock dockets. The clock dockets arise because of delays in the trial and delays in the decision-making after the case is submitted for decision. Now, in delays in the trial, we have instituted mediation and judicial dispute resolution. Between the two of them, judicial dispute resolution and mediation have screens out about 78% of cases filed. So out of 100 cases filed, 78% are settled amicably between the parties through mediation and judicial dispute resolution. Now, we still have, after JDR, we have pretrial. And I think at pretrial, we can still increase that by 5%. Now, we have adopted mediation and JDR for only 5 years. And I think with more training of mediators, with more training of judges, we can improve the efficiency rate. The objective, I think, is to make sure that only 10% of cases filed go to trial. And I think it's doable. We have introduced mediation and judicial dispute resolution in 80% of our courts, and we are expanding that to 100%. So we will be able to filter cases filed and allow only the trial of about 10%. Now, in the trial of 10%, we have adopted the small claims court, where there's only a one-day hearing, and at the end of the day, the judge will issue the decision. No lawyers are allowed, and it's very inexpensive part on the part of litigants. Now, aside from that, for purposes of we have to simplify the pre-trial procedure, the trial procedure in courts right now. It's so cumbersome and so antiquated. So we have experimented with simplified trial procedure in the revised rules on summary procedure, the interim rules on intracorporate remedies, the rules on environmental cases, and the rules on intellectual property rights, where in lieu of direct testimony, you have judicial affidavits. And if you have that, you cut down trial time by 1/2 immediately. And we have prohibited dilatory tactics like motion to dismiss, motion for a bill of particulars, motions to postpone, petitions for certiorari, prohibition of mandamus against interlocutory orders. These have been prohibited in these simplified rules, and the practitioners and the public have accepted that. It's about time that we expand this to all the civil cases. If we expand this to all the civil cases, then we cut down trial time by at least 50% in all civil cases. Now, I'm also suggesting that the party should be required to submit memoranda of facts and law before the case is submitted for resolution, because this helps. Even here in the Supreme Court, the memoranda of the parties help us a lot in deciding cases. And when I was Chief Presidential Legal Counsel, I introduced the procedure in administrative cases that one, direct testimony shall be by affidavit, and two, that the party shall submit draft decisions. And this is how we were able to clear the 20-year backlog in the Office of the President. So I think the party should be allowed to submit memoranda of facts and law, and the judges should be allowed to adopt this in whole or in part, so that we can fast-track the period of time to decide cases from the time they are submitted for resolution.
Yeah, I'm satisfied with that answer, Chief. So justice delayed is justice denied. That's the most important. Second to the last question. Kagabi, tinitingnan ko rin po yung voting records nyo eh. Kagabi, tinitingnan ko at like say yung mga important cases, yung Pea Amari, yung dineclare unconstitutional. Ang alam ko naman sa Pea Amari, di ba, parang time ata ni President Ramos yun eh, yung contract. But despite serving with as Chief Legal Counsel ata po, no? ng former president, you decided against that contract. Yung MOA AID, MOA AD, declared unconstitutional, doon din po kayo. Yung RP-US Visiting Forces Agreement, you dissented. Yung NERI versus ES, yung gusto niyo po, even yung basic rights, yung rights ng information, ay yun ang gusto niyo. So parang, tinitingnan ko po parang personally, parang sabi ko, sakasakali we're in good hands, di ba? Pero nung impeachment, ang nangyari, whether you like it or not po, parang nag-benefit rin ho kayo di ba? Sa impeachment. Without you knowing it. Dahil personally, kayo po yung naging acting Chief Justice ngayon. And there's also a possibility because of your record, because of your integrity, competence, that you will be appointed Chief Justice of the Supreme. There's a possibility. It depends on the President. Prerogative ng Presidente yan So, ito po yung considering po ito yung mga factors na to. How would you assure the nation na you would still continue to be as independent-minded as you are?
Well, I can assure everybody that I will continue to be independent. For the last 11 years that I've been in this court, I have maintained a consistent judicial philosophy. And regardless of the political consequences, I mean, if I wanted to be Chief Justice then, I could have voted for the Chacha. I mean, but what?
Yeah, I forgot that. Chacha is also one of the
because that was
cases.
That was a turning point in our history. I mean, we could have become a parliamentary government, and somebody would have stayed there for longer term. But why would I do that for myself? I'm not looking at this for myself. I have so much respect in the Constitution, and if the Constitution has to be amended, it has to be amended in accordance with the Constitution. I was in law school during martial law, and when the Constitution was amended outside of the process provided in the Constitution, I questioned whether I should still be a lawyer. But I persevered. And so I have that desire to see to it that this will not happen again. That's why I also oppose the Chacha of former President Ramos, because I think the Constitution should not be just amended for the sake of one person. It should be enduring. And you can be assured that I will maintain that philosophy because I have so much respect for the Constitution.
Last question, Mr. Chairman. This is the last question. Nung kasagsagan po ng impeachment, I observed, dahil doon po kahit sa Iloilo, for example, may mga nagsasabi doon na may mga galing dito na instructions na magsuot ng pula, diba? Yung mga court personnel, kahit yung mga court employees, tapos parang mag-rally, diba? Yun ang nangyari. Nakita po natin na hindi naman lahat, diba? Hindi naman lahat, may paninindigan naman yung karamihan, pero maraming ganon. Ang kahulihan tanong ko lang po sa inyo na para sa akin importante, I hope this will never happen again. We don't want to do this again. Pero kung kayo po si CJ Corona, kung kayo po siya, ilagay niyo yung sarili niyo sa kanya at that time. Ano po sana yung ginawa niyo?
Well, the other day I was asked if I would want to see the employees wear a certain color for today to show their support for me. I said, no, please don't.
Yung mas importanteng tanong ko po, aside dun sa color, kung kayo po si CJ Corona, and alam naman natin kung ano yung nangyayari, di ba? Ano po sana yung ginawa nyo?
Well, I think if you are subject to impeachment, you just have to proceed with it in a very dignified way. Because there is a process that will have to be followed under the Constitution. And let that process continue in a dignified way. That's the way I look at it.
So, ibig sabihin, kung kayo po si CJ Corona, tama, nagpatuloy pa kayo, hindi kayo nag-resign. Kung kayo yung sa kanya, kung ikaw...
Well, I wouldn't know what exactly was on his mind. I wouldn't
No.
exactly.
Chief, assuming lahat, given kasi lahat. Given yung variables. Yung factors given, alam na natin. Diba? Looking back, alam natin ngayon ang nangyayari. Exactly, day one na ginawa namin yun. Alam na natin sa ngayon. looking back, kung kayo po yun? That's my question. Gusto ko lang, kailangan ba nating daanan yun or may konting sacrifice?
Well, if
Resign or, my question is just simple. Magre-resign po ba kayo to save the nation na nangyari or tuloy?
well, if I misdeclared my son to that extent, then I would resign right away.
Thank you. Thank you. Good luck, Chief.
Thank you.
Thank you, Mr. Chairman.
Attorney Cayosa, please.
Thank you, Mr. Chairman. Good morning, Chief.
Morning.
I called my questions from your speech before the IBP Central Luzon Regional Convention, where you outlined your proposals for judicial reform. And one particular section of your speech struck me because I was an accredited mediator prior to my appointment to the JBC. And you actually confirmed that mediation and judicial dispute resolution are huge successes in the battle to decongest the dockets of trial courts. In fact, you cited earlier that about 78% of the cases referred to mediation are successful. So mediation is indeed a useful tool to decongest the dockets. But I observe that the mediation center established to oversee and manage mediation center units all over the country is merely a division at the Judicial Reforms Office of the Philippine Judicial Academy. As it does not have a budget of its own, it has to rely on whatever available funding PhilJac can spare. The mediation units nationwide are managed by mediation supervisors who are contractual, not regular employees who have served for more than 5 years. In my personal experience, when the mediation unit was set up in Tuguegarao, we had to squat at the IBP office. We had to use the facilities of the IBP and the courts just to encode and print out our compromise agreements because the printer, only the printer from the court came to the unit 6 months later. What do you needs to be done in order to enhance mediation and to ensure its continuity, as well as judicial dispute resolution as a way to declog court dockets?
Well, you're right. Right now, the offices of the mediation centers are in an ad hoc capacity. But I have already asked the PhilJac board to do some computation. How much does it cost to resolve one case through mediation as compared to resolving a case through trial? And I'm sure the cost of resolving a case through mediation is very cheap compared to a full-blown trial. And in fact, in mediation, the cost of mediation is paid for by the parties. So it's very inexpensive on the part of the government. So with this data, I want to present this to Congress, that Congress must give us funds to set up these mediation center offices because it's costing the government much less to settle cases through mediation than to have these cases go through a full-blown trial. And those are the figures that I think Congress will understand. And the PhilJac now are cracking up the numbers for this, and I hope to bring this up to Congress.
One more criticism about mediation is that the minute you file a case, you have to pay for mediation fees, even if there's no mediation unit where you are filing that case. And we have yet to see what happens to these fees. Supposedly, I mean, I would like to think that they should be segregated and to be used really for the Philippine Mediation Center, but we have yet to see that.
Well, all the funds paid for mediation fees are used for mediation. First of all, since it's a new concept, we have to train mediators, and we spend for that. So part of that of the money used in training come from the mediation fees. Now, we have already mediation units in 80% of our courts, and it's now being rolled out to the balance of the 20%. So what you said earlier, that mediation fees are still paid even in places where there are no mediation, but that will soon be over. But rest assured that all the mediation fees paid by litigants go to train mediators, to pay the contractuals who are manning the mediation centers. The funds are segregated. And they're not even the interest income go back to the fund. The COA wanted to require us to remit the interest income to the National Treasury. But I said, these are trust funds given by the litigants for mediation of their cases. And this mediation is paid to a private mediator. So these are not actually public funds, but these are funds of litigants to resolve their own case. And, well, I think they agreed. So we are not remitting anymore the interest on these funds, but we're plowing it back into the principal.
Thank you, Chief. I am actually happy that we have an acting Chief Justice who is computer savvy. And I was happy to note that you have already distributed nationwide USB 3G wireless thumb drive, which will allow connectivity with judges nationwide. That's on the assumption that they are all computer literate. Do you think we should make that a requirement under the JBC for an applicant to be computer literate before they can become judges?
Well, first of all, the bidding for the USB thumb drives will take place tomorrow pa, because the court had to approve it, and bank approved it, and the bidding is for tomorrow. But before the end of August, we will be able to start distributing this to all the courts. Now, your question whether the JBC should require applicants to be computer literate, I think computer literacy in terms of at least knowing how to use the word processor is essential now. I mean, I don't know of any graduate of law school who doesn't know word processing now. So I think we should train our judges to use also word processors, because it will help them in legal research, because they can just copy and paste from the e-library. They can download, and it's practically essential. We have created an e-library which contains all the decisions of the Supreme Court from 1901 to the present. It contains all the laws of the Philippines from 1900 to the present. It contains all the rules and regulations that are on file with ONAR, because these are the rules that have public, that affect the public. And we are now adding the presidential issuances. So it will be unfortunate, really, if judges do not use the e-library. And I will go along that they should be trained how to use the computer.
Thank you, Chief. Now, apart from the connectivity, allowing them access to the e-library, I understand that you are also going to use this as a case monitoring system, because they will have to download their reports. I hope that there has already been an effort to, because I think one of the problems in case monitoring is the integration of the different systems, because sometimes it is not compatible. The reporting system cannot be done electronically because of the incompatibility of the systems. So that the information, especially for us here in the JBC, when we want to see how a judge has performed, we have to rely, first of all, on their reports, which may or may not come on time. So I think this is also essential in making decisions regarding court administration. But how long down the line do you anticipate it will take for us to be connected so that we can get the information regarding the caseloads?
Well, we have already the case management system of the Court of Appeals in operation for the last 2 years, and it's a huge success. Everybody is saying that it works, and in fact, PJ Reyes said by the end of this year, they will already comply with the constitutional directive that all cases submitted for resolution must be resolved within 1 year for appellate courts. Now, we are replicating this case management system in the trial courts. And before the end of this year, maybe September or November, we will pilot test this in certain courts in Metro Manila. And once we are happy with the system, it will be deployed nationwide, and the system will be uniform. That's why we will not have problems on incompatibility, because everything will be uniform. We will be following the system that originated in Court of Appeals, which we will also use here in the Supreme Court later on by just adapting it.
Thank you, Chief. I have a question on transparency. From what I recall, from being in the court, although that was quite some time ago, there is so much information coming out of the Supreme Court. And for the first time, we are conducting JBC interviews live on all types of media. How do you think this will affect the court, especially if there are certain matters that need to be held in confidence? How does the court adjust to this? I think the advent of more transparency through the use of the different media.
Well, I think transparency is a fact of life because of technology, because of the demands of the public, and because it's there in the Constitution. Now, however, when it comes to decision-making in judicial cases, we still retain our confidentiality up to the time we make a decision. Once we make a decision, we post it online, and you can see there who voted for what, who dissented, who concurred, and the names of the justices are there. But in the process of making that decision, our drafts that we circulate to each other, our discussions, will have to remain confidential, because otherwise it will be difficult, really, to be candid with each other in our discussions if even these discussions are monitored. But I think that is followed all over the world. The discussions of collegial courts remain confidential. But once the case is decided, we allow, even once the case is terminated, the public to access the records, because these are public documents.
Thank you. Mr. Chair, I just have two more points. With respect to allowances of judges, lower court judges, and I believe even the justices, you stated in your speech that you would allow this, except that it would be to a common fund. What have you developed a policy to be adopted in the distribution of this from this common fund to the judges and justices from the LGUs?
Well, I have discussed that already, and my proposal was we will adopt a common fund, just like in Cebu, where the government, the LGU, will contribute directly to the Supreme Court, and it's the Supreme Court that will give these judges stationed in that area. Actually, this was a proposal about 3 years ago by then Mayor, now Vice President Binay, because he said, I don't want to be bothered giving funds to the judges. I want to give it to the Supreme Court. And it was actually his idea. So I think even the local government officials want to do this. So we will work on this by talking to everybody, and we'll have a template agreement for everybody to sign.
For my final question, this is with respect to the JBC. I fully subscribe to your suggestion that the JBC must give greater weight to the decisions of applicants who seek promotion in the judiciary. And as a rule, I make it a point to read something or anything that they have actually written when they apply and before they're interviewed. You also suggested that the requirement to submit not only a statement of assets, liabilities, and net worth, but also a waiver to determine the integrity or honesty in declaring their assets should be made a requirement of all applicants to the judiciary. Now, there is need for personnel to validate information that is given to us. In the past year, the JBC evaluated 2,969 applications for 195 positions. The bulk of these applications, or 2,640, went for 183 positions of courts nationwide. Currently, the JBC only has 76 regular personnel. The JBC needs additional regular personnel to conduct comprehensive background check and verification, among others, to check on these bank accounts. Otherwise, it will just be for naught that we have this information. What do you propose to do as our acting chairman?
Well, I think you have to develop a core of lawyers who will help you evaluate all of these decisions. Just like in the Supreme Court, we have our law clerks who help us do the research on cases. You should have your own set of lawyers to do that for you. Or you can have a pool for everybody. And I will support that. If and we can work out with the DBM that this be made into part of your plantilla. Because I think that's necessary. I think the best way really to find out the competence, integrity, probity, and independence of a person, if he's a judge already or a justice, is to look at his decisions. Because you will know whether he's competent in the law, whether he has favored any litigant, whether he has been independent vis-a-vis Congress or the executive or the LGUs. I think it's there. It's the track record of a person.
Thank you, Chief. That was my last question.
Thank
I
you.
wish you luck.
Thank you.
Thank you, Mr. Chairman.
Attorney Ahab, please.
Thank you, Mr. Chairman. Good morning po.
Good morning.
Justice Carpio. Alam po ninyo, I have been asked before about my thoughts on the impeachment, that went on, and I mentioned that I think the impeachment was not only against the former Chief Justice Corona, but was an outburst of the frustrations of the public with the judiciary. At I'm starting with this statement po kasi ang dami-dami pong tweeted, that texted questions na mukhang ganito po yung isinasaad ng damdamin ng publiko. Kaya po minarapat ko na paghaluin yung tanong ko, yung pinrepare, isa o dalawa sa mga questions that I prepared, and then siguro po kadamihan yung pong suggested questions at saka po isa o dalawa dun sa opposition para po mailahad ninyo ang inyong posisyon dito. The first question po that I have in mind is, what was it like for you during the entire episode of the impeachment trial?
Well, like everybody else, I was following it. But, it was weird because in the court itself, we hardly discussed it. We did not discuss it in division meetings or even in the bank. Why? Well, I said it's weird. That's how it happened. I would discuss it with my staff, but with the justices, we didn't discuss it, as far as I'm concerned.
Do you think there is a remedy or venue available for the people who wish to proactively participate in the affairs of the state rather than wait for the legislature to fill in the gaps? No, I think this is reference po to the Lambino case.
It's a question regarding the people's right to amend the Constitution.
Opo, I would take it to mean that po.
Well, the people's initiative provision is there in the Constitution. It's a constitutional right of the people. And I think the people should exercise this right. But in exercising this right, the people should not be fooled into just signing something that they don't know. The people's initiative started in the United States, in several states there. And they have developed abundant jurisprudence which says if somebody goes to you and asks you to sign a people's initiative without showing you the actual provisions that they want, then that is fraudulent. You have to show them beforehand the actual provisions that they want to be written into the Constitution before they ask you to sign. And that is a well-settled jurisprudence in the years. That's why in my decision in Lambino, I said, and I asked Ms. Attorney Lambino during the oral arguments, did you show everybody who signed these documents, these sheets, did you show them the actual provisions that you wanted to be written into the Constitution? And he couldn't answer me. He said they printed a couple of maybe 100,000 copies of the changes to the Constitution, but they did not attach it to all of the sheets. So not all of the those who signed knew what they were signing. And for me, to change the Constitution in that process is bad. And it's not allowed, because for the people must directly propose the amendment, which means that they must know what they are proposing. Either they write the amendments themselves or they concur to these amendments, which means that they were shown copies of the amendments.
Siguro pa babasahin ko itong mga tanong in group, no? Justice Carpio, paano mo ipapakita sa mga taong mahihirap na kasama kanila sa kanilang laban sa korupsyon? Isa pa po. Ano po ang hakbang na gagawin ninyo upang tiyakin na ang mahihirap ay may equal access sa services sa judiciary? Balita po kasi namin may elite background kayo.
Well, on the first issue of corruption in the judiciary, I suppose that's what they mean. Well, the first gatekeeper to ensure that those who enter the judiciary have integrity and probity is the JBC. Now, that's why I'm proposing that in appointments to the judiciary of people who seek promotion, we should look at the track record, whether they issued recklessly TROs, whether they clearly favored a litigant. That will be shown in their decisions. Now, of course, you do the regular checking with the NBI, police, and so on. But I think what is important is to look at their track record. Second, once they enter the judiciary, the gatekeeping function passes on to the Supreme Court. Right now, when there is a complaint against a judge, we create an ad hoc investigator. We name an investigator for that particular purpose only. And I think it's better to create permanent administrative tribunals because they serve as a deterrent. They are seen there as the body that will decide administrative complaints. And they can work faster because that is their job. So my proposal is to create permanent administrative tribunals to handle the complaints against judges. Now, with respect to the other question on access to justice by the poor, well, we have several programs already in place. Now, we continue to subsidize the IBP for their legal aid program, and we have exempted filing fees of clients of IBP legal aid offices. We have also exempted filing fees for clients of PAO if they are indigents. Now. And we have this small claims court where it's very inexpensive to file your claims. So, and we have, in fact, also a new law that was authored by Senator Lapid on the free legal assistance to the poor. I have instructed our court attorney to prepare already to work out the implementing rules for this because we are tasked under that law to adopt implementing rules as far as the court is concerned.
Thank you po. Marami pong judges ang late sa kanilang hearing and even do not appear without notice, wasting people's money. What can you do about this?
Well, the Office of the Court Administrator has to be tasked to monitor those situations, no? And that will be solved, however, with the forthcoming case management system. Because in the case management system, it will show there the actual work, the incidents of a case. So judges cannot complain anymore. We cannot give excuses that they have so much cases, that they have they got sick and so on. Because at a glance, you can see the aging of cases, the caseload of a judge, the number of days he had hearings, the incidents that he decided on that case. So everything can be seen there by the executive judge and by the court administrator and even by the Chief Justice.
Siguro po last 2 or 3 questions, no? Babasahin ko na pong sabay ito. Yung isa po, yung opposition ni Mr. Dante Jimenez. Mr. Dante Jimenez is opposing your nomination because he will be, and I quote, he will be a biased Chief Justice because he represents the old boys club in the Supreme Court. Babasahin ko na rin po yung isa pong tweeted question, texted question. Pakitanong naman po kay Justice Carpio kung may impluensya ba ang Sigma Rho sa kanyang mga decisions.
Well, on the second question, in fact, I voted for the dismissal of a member of our fraternity, a Court of Appeals Justice, to be dismissed. I voted for the dismissal. And on the first question, on the complaint of Mr. Jimenez that we are an old boys club, I think the decisions of the court will show that we are not a club. We have heated discussions and we have strongly worded dissents against each other, and I don't see how we can become an old boys club. I mean, when it comes to judicial decisions, we fight very hard for our position. And I don't think, if we look friendly, it's because we have no choice. Your ally today in a case could be your enemy tomorrow, and your enemy today could be your ally tomorrow. So you have to be civil to each other, even as you fight each other. Because your opponent today could be your ally tomorrow. There are no permanent enemies in the court, no permanent friends. You have to stick to the issues, fight for the issues that you want.
Pong sa Sigma Rho. Pakitanong naman kung may impluensya ba ang Sigma Rho sa kanyang decision.
Well, I've answered that because the court dismissed Sigma Rho 1.
Okay.
And he was already a Court of Appeals judge, and I voted for the dismissal.
Okay. Sorry po, hindi ko na... Yeah. That's my final question po. Good luck, Justice Carpio. And
Thank you, sir.
Mr. Chair.
Justice Lagman, please.
Very much, Mr. Chair. Justice Carpio, good morning.
Good morning, ma'am.
Now, you have been with the court for more than 10 years already, and is the acting Chief Justice for 2 months. I think almost 2 months. Do you think it is fair for the judiciary to be receiving only more or less 1.25% of the national budget?
In other countries, they have fixed the budget of the judiciary at 2% of the national budget. And it seems that that would be the ideal. Our budget, they have said that our budget has doubled over the years, and it has doubled in absolute amounts. When I joined the court, the national budget was just a little less than 1 trillion. Now it's 2 trillion, so it has doubled. And our budget naturally has doubled because the doubling was caused by the doubling of the salaries of employees. In the last 6 years, the salaries of government employees have doubled across the board. So necessarily, the budget also almost doubled. But as a percentage of the national budget, the budget of the judiciary has declined. In 2011, our budget in the judiciary, total judiciary budget, was 1.36% of the national budget. This year, it is 1.21%. So the Constitution says that the budget of the judiciary shall not be reduced compared to the previous year. But does that mean that it will not be reduced in absolute amount, but as a percentage of the total national budget, it may be reduced? That's an open question, and I don't want to answer that because that could come before the court. But it's food for thought. Because the budget would necessarily have to adjust to inflation. If everything doubled, of course our budget will double. But has it actually increased in real terms?
Okay. Justice Carpio, now in this connection, do you have any proposal or do you have anything in mind as the acting Chief Justice in regard to budgetary reforms for the justice system?
Well, of course, I would like to see in the annual General Appropriations Act a program construction of our courthouses over the next 10 to 15 years. Because right now, only 20% of our first-level courts can be accommodated in halls of justice, and only 50% of our second-level courts can be accommodated in halls of justice. So we have a long way to go. But of course, I realize that the government cannot, Congress cannot appropriate this at one time. So we have to budget this, program this over 10 to 15 years. As long as every year we construct something, that's, I'll be happy with that. But we have to make sure that we are addressing this problem, because the work conditions of judges is also important for their efficiency. So I would like to see that in our annual GAA, that we have a definite amount to fill up the shortage, because half of our first-level courts are not housed in halls of justice. They're scattered, they're leasing in some apartment even, or they're squatting in municipal offices.
Okay. My next point, Justice Carpio, is about the GLAC, the Judicial, Executive, Legislative, Advisory, and Consultative Council. Do you think there is a need to convene the GLAC to help address the problems of the justice system?
Yes, that body, the GLAC, is not in the Constitution, but it is also not prohibited. Now, that body is just a forum for the judiciary to propose to the executive how much it needs in the budget, and for the Congress to listen to that proposal. And I don't see a problem with that. And I think we need that, because we have to communicate to the executive what our budgetary requirements are. I remember during the time of Chief Justice Narvasa, I was then in the Malacanang as Chief Legal Counsel. Chief Justice Narvasa said, I want our budget proposal, our recommended budget proposal, be part of the budget proposal of the executive. If we are proposing 10 billion, the executive must propose 10 billion for the judiciary. I said, under the Constitution, it's the executive that proposes the ceiling of the budget. But we can ask your opinion. But we cannot adopt your recommendation because we are the ones who propose, the executive. The judiciary can only recommend. So our compromise was the executive will recommend the actual amount. If it differs with that of the judiciary, we will footnote the recommendation of the judiciary. That was the agreement. But I think a better way to do this is to create that body and to discuss these issues there directly with the President and with the President of the Senate and with the Speaker of the House. And that will be more efficient. Thank you.
So you think the GLAC can be an instrument in modernizing the justice system in our country?
Yes, I think that body will be great in bringing out the needs of the judiciary to the two other branches, because that's the only we can do. Because of the separation of powers, we cannot tell Congress how much to appropriate to us. The only thing they can do is they cannot bring our budget down compared to the previous year. We cannot also compel the executive to propose the budget that we want. That we have settled that already with Chief Justice Narvasa.
Yes.
So the best way really is to sit down. How much do we really need?
Okay. Now, Justice Carpio, yesterday, Justice Abad was here, and he stated that the impeachment of the former Chief Justice has wounded or damaged the judiciary. And he said that an insider could effectively lead the renewal of the court. Do you agree?
Well, on that first premise that the impeachment has wounded the judiciary, I'm not prepared to go to that extent. Okay. In fact, I have said that the impeachment was directed at a particular person, at a particular justice, and we are not affected, I mean, in terms of that impeachment. But I will not also deny that it has brought out problems about the judiciary, like the clogged dockets, corruption supposedly in the judiciary. And this has come out to the fore because of the impeachment. Okay. And we have to address this, because whether we like it or not, whether it's true or not, that's the perception of the people. The clogged dockets have a basis, although we are not to blame, because 80% of the cases pending in first and second level courts are criminal cases. And 40% of these criminal cases are drug cases. And in drug cases, the prosecution always asks for postponement because they don't have the witness, the forensic expert is not around. He has been transferred to another station, and there is no POW lawyer to defend the accused. These delays are not attributable to us, but we bear the blame because it's part of our docket. That's why I've discussed this with the justices, and I said, although we are not really to blame for this huge backlog in criminal cases, and this is really the cause of the backlog, we have to solve this because it affects us. And I have proposed that for criminal cases, before the information is filed in court, the prosecution must attach the affidavits of all his witnesses in question and answer form, so that when the trial comes, the witness will just affirm his affidavit and the cross-examination can start. And we cut down trial work by 1/2. If we cut down trial work by 1/2, chances are the prosecution witnesses like the police are still in that area ready to appear. But after a lapse of time, this police, the forensic expert are moved around, reassigned to other places, and maybe the other witnesses just disappear.
So, Justice Carpio, do you agree with the observation of some people that the impeachment has affected the cordial relationships of the judiciary with the other two political branches of government?
Well, I do not think so. When you say cordial relationship, I think you refer to the respect one shows to each other. That respect is there. It's very much there. I attended the SONA in representation of the judiciary because I have respect for the president. I have respect for the SONA process, which is there in the Constitution, which requires the president to address Congress at its opening session. While it may be a ceremony, it has a constitutional function. And I think the cordial relation is there.
Okay, my last question coming from me, Justice Carpio, is this. Past Chief Justices are remembered for the reforms they have instituted during their incumbency. Now, if you will be nominated and appointed as the next Chief Justice, can you please describe to us the face of a Carpio court?
Well, I would say that I would like the court to make the judiciary fair, honest, and efficient. And I would like to be remembered as one of those who helped make the court fair, honest, and efficient, because that will address the issue of the clogging of dockets, that will address the issue of corruption, and that will address the issue of fairness.
Okay. Now, if you will allow me, Justice Carpio, we received so many questions from the Twitter. I'll just ask you one or two. Okay, you have... Okay. Now, if you will be the next Chief Justice, should the five-strike rule regarding the bar examinations, do you think there is a need to revisit the five-strike rule regarding the bar examinations? Is it an effective mechanism to screen new lawyers?
Well, I'm in favor of the five-strike rule because after 5 tries, I think maybe you should try something else.
Yeah.
But I say that because we have clerks of court in the first-level courts who are not even law graduates. And there's a place for even those who flunk the bar. I mean, it's better to have a law graduate than somebody who has not taken up law studies at all to be a clerk of court in the first-level courts.
Yes.
So I think after 5 tries, maybe you should work on something else, but still you can still use your legal learning, your knowledge of the law from law school.
Yeah.
So I think not everybody can practice law. Not everybody who took up law can practice law because we have the bar exams. But they need not waste that learning. We can put it to productive use.
Now, there's so many questions, but this will be my last question from the Twitter. Okay. Now, Justice Carpio, what are the wrongdoings of the past Chief Justice that you won't do in case you get the post? And how would you change it?
Well, I think it was because of the son that he got impeached, the misdeclaration of the son. And I think I will never do that.
Okay. On that note, I have no more question for Justice Carpio. Thank you, Justice, and good luck.
Thank you, ma'am.
Justice Hermosissima Serhan.
Just good afternoon now.
Good afternoon, Justice.
Most of the decisions written by Justice Tony Carpio brought accolades, but in some cases, Justice Carpio was misunderstood. Well, according to Emerson, to be great is to be misunderstood. I believe that Justice Tony Carpio can bring greatness to the Supreme Court and possibly renewed glory. With that note, thank you very much.
Thank you, Justice Hermosissima.
Secretary Mosngi, please.
Thank you, Mr. Chairman. Magandang hapon po, Mr. Chief Justice.
Good afternoon, sir.
I'd like to say it is indeed a personal honor and privilege for me to propound questions to the Chief Justice of the Republic of the Philippines. Chief Justice Carpio, you started law school, and before that you were a graduate of the Ateneo de Manila University, the degree of economics, and then you started your career by entering the University of the Philippines College of Law. You and I were previously students of law. I'm sure we share the dream, the same passion of learning the legal profession in law school. I'm sure you had your own romance with law. But after law school and after passing and topping the bar, I am certain that you entered your legal career with the same zeal of idealism and hope to carve out your own sense of the legal profession. Then you entered the practice of law at namulat kayo sa tunay na mundo ng abogasiya. In the real world, you have staked your claim, you have practiced law as a member of the bar, and you have practiced law as a member of the bench. Now you are in the point of your career you're aspiring for the post that is the most coveted of any legal practitioner, every legal professional. What is your notion of this? How does the law remain still beautiful in your eyes? What is your sense of the still, right now, the beauty of the law? Has it been corrupted in your eyes after your long practice? Has it remained attractive and alluring to you?
Well, in the Supreme Court, you find the practice of law, if you put it that way, in its purest form, because you decide cases based purely on the law, based on the Constitution and on the statute that complies with the Constitution. And if you decide cases that way, then you have this satisfaction that you are applying the law in its purest form. I have practiced law in the private sector. I have taught law. I have been a legal counsel in the executive department. But I find law in the Supreme Court the best law that I can find, because here you apply the law in its purest form.
Maraming salamat po for that. Chief Justice Carpio, if you recognizing two important concepts in legal parlance, one of which is judicial independence, and the other is judicial interdependence. What do you think is best for the country right now?
Well, these concepts of judicial independence or interdependence of the branches, commingling or merger of powers of different branches, must all be found in the Constitution. And in the Constitution, you have a clear separation of powers. You have the judiciary that will decide what is the law with finality. You have Congress that will promulgate the law, that will enact the law, and you have the executive that will implement the law. But you have also, under the Constitution, an area where there is a check and balance. You have the impeachment power of Congress to check the Supreme Court and the executive. You have the power of appropriation of Congress to limit the expenditure of the executive and the judiciary. And you have the power of the executive to propose to Congress what should be the budget. Congress cannot increase it beyond what is proposed. So here is a merger of powers. Congress is supposed to have the power to appropriate, but it cannot appropriate more than what the executive proposes. Now, the executive is supposed to spend the money, decide how to spend the money, but the judiciary has fiscal autonomy, and the executive must release automatically and regularly the budget of the judiciary. And the judiciary may realign if there is a law. You cannot realign savings without a law. So again, there is a check and balance. So the other concept of interdependence or commingling or merger is actually this check and balance. Then you have the third concept of merger of functions, interdependence of powers. Here in the JBC itself, here in the JBC, you have one representative from Congress, one representative from the executive, one representative from the judiciary. The three branches are sitting together, exercising a power, the power to screen out nominees. But they are only screening out. The ultimate power to appoint from the list comes from the president. See, the power of appointment is supposed to be with the president, but this body is sharing it with the president by limiting the choice of the president. And this body is composed of the three branches. But still, we have the regular members of the JBC, you have 4, and they're appointed by the President with the consent of the Commission on Appointments. So it's the power shared again between the executive and the legislative. This is, I think, an example of interdependence, if you want to call it. I would prefer to call it convergence of powers. Still, there is another area of convergence of powers, and that is the budgeting process. And I have mentioned that already. So, whatever you may call it, you call it interdependence, independence, commingling, merger of powers, it must, however, be found in Constitution.
Maraming salamat po. Just two more, Mr. Chairman, please. One of which is, do you plan, after retirement, do you plan to practice law again, Mr. Chief Justice?
No, after retirement, I plan to teach in the UP College of Law, maybe also in Ateneo de Davao if I have a chance to go back to my hometown.
As a final question, Mr. Chief Justice, we lawyers, we are aware of certain legal and immutable principles, one of which is the presumption of innocence. Another is the presumption of regularity in the performance of public functions. And the third that comes to my mind is the presumption of good faith in all our dealings. If I may solicit your opinion, very respectfully, Mr. Chief Justice, do you think that the pendency of an administrative case against a nominee for Supreme Court justice should bar him or her from being considered?
Well, I would like to be excused from answering, but in any case, I will answer that. That decision lies with the JBC. You adopted the rule. And if you want to exempt anybody from the rule, you can exempt it. It's up to you, really.
Again, maraming salamat po at thank you very much.
Thank you, sir.
Mr. Chairman.
Thank you, Secretary Mosngi. I'm thinking of questions to ask. Anyway, because they already asked about your programs, Chip, how to solve the clock dockets, computerization, lahat na tanong na about your programs. Tanongin ko naman kung your functions now, what are you doing, so that the public may be enlightened, because you have been in the court for 11 years. I remember when I joined the court, my first time to come to this court, you gave me a book about justices of the Supreme Court. And then I had problems then because I had the most number of cases. I think I inherited 1,300 cases. And also remember that you told me that it will take time before you get rid of your docket. And I vividly remember, and you told me that in order to learn the work of an associate justice, you need at least 3 years. Do you recall that, Chief Tony?
Yes.
But because I was ashamed to ask a follow-up question, I did not ask you. Kasi ibang dating sa akin Well, there was a time that my wife worked with you in a case when you were the Presidential Legal Counsel. When I was newly married, I used to fetch my wife in all these meetings. Yung ibang dating sa akin nahiya ako So I did not ask him. Sabi ko, parang natakot ako. You need at least 3 years to learn the work of a justice. Sabi sa akin, natakot ako Eto, tatanungin ko na ngayon. Tatanungin ko na sa kanya. Why did you give that answer to me, Chief Tony?
Well, in my case, it took me 3 years to really be comfortable with the work here in the Supreme Court. There are a lot of procedures here in the Supreme Court. And for you to really battle it out in the discussions in the Supreme Court, you must have a firm grasp of a wide range of areas of law. And for you to learn this and to have a full grasp, you must do this every day. And after 3 years, then you are ready really to discuss point by point any aspect of law. I said it took me 3 years really to feel that I can speak with authority in the en banc and battle it out with the justices like Justice Mendoza, V.V. Mendoza, with Justice Davide, Chief Justice Davide. And that's the reason why I said it takes 3 years, really.
What about, because you are vying for the position of Chief Justice, you need 3 years to learn the work of an Associate Justice. How many years do you need to learn the work of a Chief Justice? That's why I did not join the nomination, because this is only my 4th year. So I want to ask him, how many years do you need to learn the work of a Chief Justice?
Well, I think to hit the ground running, you must know immediately the problems of the judiciary. And to know the problems of the judiciary, you have to observe it for a length of time. There are so many problems in the judiciary. That's why people are complaining about clogged dockets, alleged corruption in the judiciary, lack of infrastructure. And we have to address this. And it took me some time, really, to find out these problems. Right now, for example, I just talked with our people in the Office of the Halls of Justice. They have problems of paying on time. Utilities in the provinces, they're unable to pay on time electricity bills, telephone bills, water bills of courthouses, of halls of justice. So I told them, look, you get the list, get the bank accounts of all these utility companies, and we deposit the check here in the land bank. And we just tell them the check is deposited already in your account here in the land bank. Right now, what we do, all the courts, the clerks of court will send the bills to Manila. We process it here, we prepare the check, we mail the check, and along the way, the checks get lost. When we can all the time just deposit it here. And there are so many problems like that. And you will remember that in the en banc, we always agonize because we always dismiss clerks of court who run away with cash collections. And it happens all of the time, all these years. So I called up the OCA the other day, and I told them, I want, this is a simple problem. I visited other judiciaries abroad, and I asked them the same question. How do you safeguard the funds of the judiciary, the filing fees, when they are paid to your clerks of court or cashiers? Said, we don't have that problem. Why? We require them to pay the bank directly or to pay us in check. So there's no leakage. And that's what I told the OCA, to prepare a circular that I will sign requiring all clerks of court not to accept cash anymore, to accept checks. And if there is no checks, the filing fees will be paid to land bank branch. And most of the municipalities, municipal halls where the courtrooms are located, are just across land bank branches. And so the land bank has given us a list of all their branches nationwide, which are located beside courthouses. And so the clerks of court cannot complain anymore that the litigants have a hard time preparing the check. They don't have checking accounts, or they cannot. They only have cash. Well, if they have cash, they can go right across the street where the land bank branch is located. And we can just do away with all of this revenue leakage. Now, all of this takes time to understand. And it took me a long time to understand this problem.
Another thing, because you are the longest serving member of the court, probably the public do not know. Aside from our functions in the court, adjudicatory, administrative functions, you are also members of the HRET and SET, is it not?
That's right.
You were once a chairman of the HRET.
That's right.
I now sit as a member, but not yet a chairperson. It will take time also, because I'm just learning. And then you sat also as a member and chairman of the SET. Will you please enlighten us, what were your functions as chairman of the HRET?
Well,
the House Representative Electoral Tribunal, for that matter.
Well, in the HRET, every election you receive around 140 election contests. And you have to decide this before the 3-year term of congressman, and otherwise it will be useless. Before, when the elections were manual, we have to go over each ballot one by one. And of course, the objections are written by one hand, several ballots written by one hand. And it was very tedious to go over this. Now it's automated, but still the parties want to go to the ballots instead of just relying on the flash drive. And of course, you have to decide these cases before the end of the term. Otherwise, it will be useless. So it's a lot of work in the HRET.
What about, have you presided already a meeting of the monthly meeting of the Philippine Judicial Academy, being the chairman of the Board of Trustees?
Yes, Judge, I have already presided, I think, twice.
Oh, that's also another work for a Chief Justice.
Yes, that's the Chief Justice chairs that body.
You also chair the what we call the Mother Rule. The
Mother Rule Committee.
Yeah, the Mother Rule Committee, the revision of the rules of court. Then you chair the Judicial Bar Council.
That's right.
And you should be on top of what is happening of our budget.
Yes, that's the function.
Can you also, because I'm not yet there, no? I'm not yet there. I do not know. These are the only important committees that I remember. Are there other committees that you chair where you have to pay special attention? Yeah, I remember now the PMO and the GRSP, the World Bank loan, and so on.
Well, the Chief Justice is on top of all of the administrative functions in the Supreme Court and even in the lower courts through the Office of the Court Administrator. The OCA Administrator reports directly to the Chief Justice. And a lot of the problems are in the trial courts. And a lot of administrative work. When I sat down as acting chief, 90% of the papers that I sign are on travel authority. A clerk of court in Tagum wants to go to Hong Kong during her leave of absence. You have to approve that. And I said, we sign all of these documents and we never disapprove any of this travel authority because they are all on their approved leave. So I said, we just decentralize this to the OCA, and that's what I've done. I've been decentralizing a lot of this work because otherwise you'll do nothing but sign all these papers.
Yeah, before you became the, shall I call, acting Chief Justice or senior or what? You were once a chairman of a division. In fact, I was one of your members. Can you tell us what you actually do as a chairperson of a division in the court?
Well, as chairperson of a division, you have to see to it that the decisions, the draft ponencias, do not conflict with the ponencias of the other divisions or with the en banc. That's your primary function as chair. Then, all of them submit the synopsis. Synopsis is a practice I introduced when I joined the court. Because when I joined the court, everybody during the meeting will present orally the case. And I would see them reading. And I said, why don't you just give that to me and I will read it the night before so that the following day we can decide that fast. And so that became a practice in the entire court. So everybody submits a synopsis. Now, it's the chairman who must see to it that because in those synopses we decide whether to dismiss an appeal outright or not. So the chair is responsible to see to it that that synopsis is correct. And that is the responsibility of the chair. Now, the chair is also responsible for seeing to it when he certifies the decision, when it's already signed by everybody, that there are no typographical mistakes. I mean, you have to see to it because it will reflect badly in the court. Grammatical, typographical, that's even your problem. And so I have a staff who goes there, but I have to read again to make sure. There's a lot of reading. I stay awake up to 12 midnight before a division meeting just to read all of this. And sometimes I cannot finish, so I wake up early so that I can read everything before the 10 o'clock session. So it's a lot of work, really. It's here people, when they coming from the Court of Appeals and they realize the work, they are shocked. And they said, life was so serene and happy in the Court of Appeals. Well, he said, well, you better work on your cases because you will have a lot of backlog. And in fact, I was telling Justice Sereno, you better decide on those cases right away because if you postpone and postpone, you have to require them to submit a memorandum already and you have to write a full-blown decision. At this point, you can just dismiss that outright if you want, because why do you have to write a decision when you are just affirming everything that the Court of Appeal said? So if you just affirm, don't write a decision anymore. You know, 5 years, when I was doing the court, I was aghast that we have to write a full-blown decision when we are just reprimanding an employee or a lawyer. When we are only fining 1,000, we have to write a full-blown decision which is published in the SCRA. And I said, why do we spend so much time writing a full-blown decision for these minor matters? And it took me 5 years to convince the court to adopt the zero backlog policy. In that zero backlog policy, I said, optimally, the Supreme Court can decide only 1,000 cases a year without being reckless. We can decide 1,500, but we will be reckless. We will not polish our decisions. We will not be able to really give our thoughts to it. So optimally, we decide 1,000 cases. If we can decide only 1,000 cases, that means we cannot accept more than 1,000 cases for the writing of full-blown decisions. We must filter these cases. So how do you filter the cases? First, if you are just repeating what the Court of Appeal said, you are just reiterating, you are not changing anything, why do you have to write a full-blown decision? So we just dismiss that outright. Now, you write a full-blown decision only if you are reversing or modifying the decision. Also, we have a lot of administrative cases because we have 28,000 employees in the court. And as I said, we just reprimand or admonish, you have to write a decision. So we adopted the rule under the zero backlog policy that if the penalty is less than 10,000 fine or less than one year suspension, you can say that we adopt the findings of fact of the investigator and the conclusions of law investigator, and you attach it to that resolution. So we have cleared a lot of these administrative cases. So, you know, you start with the premise that we can decide only 1,000 cases a year. And from there, you will have to find out how to fill these cases. Now, you might, you know, the Supreme Court of the United States decide only 90 cases a year. They have 9 justices, and they decide only 10 cases per justice per year. We decide 1,000 cases, full-blown decisions. That's an average of 66 decisions per year. In other words, we decide 6.6 times than a U.S. Supreme Court justice decides. So, and in fact, other justices in other judiciaries ask me that, and I tell them, we decide about 66 cases minimum. That's our average. And he said, that's being reckless already. You should decide less than that, otherwise you cannot give it a lot of thought. But I said we can do it because we have a big staff. But, you know, there has been an explosion of cases filed in the court because we have now almost 100 million people. And you expect a lot of cases if you have a population of 100 million. So we have to devise ways how to decide these cases.
You are now an acting Chief Justice, and you are the presiding officer of the NBank. Do you still preside the deliberations in the First Division, Chief?
Yes.
Second Division, I mean?
That's right, Justice. Unfortunately, because I still remain as chair of the Second Division, I have to attend to the Second Division, I have to attend to the NBank, I have to attend to the PhilJA, I have to attend to everything that a Chief Justice attends. So I'm actually doing the job of 2 offices now, and I hope that this process will end so that I can go back to the job that should go only to one person.
You may or you may not answer this question. is there then an edge of an outsider over you? I said you may or you may not.
Well, I think in terms of knowledge of what the judiciary needs to do to be fair, honest, and efficient, I think we in the court will have an edge because we know the problems. But that may not be the only consideration. There are other considerations, and I will respect the considerations that the President will follow in exercising his prerogative. But as I said, when it comes to knowing the problems of the court and when it comes to really understanding and discussing and finding solutions, I think we have done that. And that's why we have a lot of these initiatives now and that we're doing.
Huling tanong. Galing sa Twitter ito po, ha? Tagalog kasi, so Tagalog ba ito? Ay, English pala. You may or you may not answer. Having been very good friends before, compares even, do you think that you can ever be friends with the former Chief Justice?
Yes, why not? I mean, we can always forget and forgive.
Yeah. Have you seen him lately?
No, unfortunately, I haven't seen him lately.
Do you want to see him?
Well, we actually invited him during our inauguration of the Angeles City Hall of Justice.
In Angeles?
In Angeles City, because he was also the chief then when that was being constructed.
Oh. Yeah. Okay. On that note, Chief, wala na. No more. No more questions from me.
Thank you, Your Honors.
Okay, okay, we will. Members, anong oras tayo mag-balik siya? Okay, it's already 12:40. We will suspend the proceedings now, and then we will proceed at 2:15. 2:15. It's already 12:40. 2:15, no? 2:15. Okay. So thank you very much.